Okay, good morning. This is Senate Natural Resources and Energy, and it is Thursday, February 5th. And we are starting with a new draft of S-138 about commercial properties as clean energy. I feel like I should tee this up a little bit. Been in touch with groups like Commercial Pace Alliance,
Sure.
and other folks who have a good, well, who know pace, and so we've been working together with that, which is great. And so I'm feeling like I have a much better understanding of how the program is supposed to work. And I want to acknowledge that, again, this is not a final draft. However, I think it is much closer, and one of the keys here is that envisioned in this draft is a program administrator that would be statewide. And there's, I think, a couple of agencies that might be good candidates for that. And I have a meeting with one I hope will potentially take this on later in the day. But you'll see in here that there's just listed an agency that's not specified as a placeholder for who would be the statewide program administrator. And another one of the things that was on my radar to change was about the role of municipalities in this. And so this, I believe, makes it clear that it is not the municipalities who are the ones who are on the hook for any of this money. They are not the ones that are lending. They are basically to work with a third-party credit institution, and forget what we call them. They are called something. So there's, yeah, I think that is it for now. Do you want to, there's some yellow here, but really it's the whole draft that is new. Is that, no? Okay. All right, maybe I don't know. No, okay, all right. Maybe I just forgot to compare it to the original, but there we go.
Yeah,
Okay.
Ellen check out the Office of Legislative Council. I'm here on S-138. Today you have a new draft. It is draft 3.1. There was no 2.1. So the new draft is 3.1. The changes from the prior draft, which you all have in 1.2, they are highlighted in yellow. The rest of the bill is the same. The exception being the program administrator language. I didn't highlight the entire section, but that is new. So I can walk you through it. So start going through just the yellow, which is new. On page 1, section 1, the first change here is down at the bottom of the page. It's changing from the prior draft that the municipality may incur indebtedness. And now it is the municipality that should, oh, sorry, one more thing. This is an unedited draft that I did last night. So I already caught a couple of typos in here, but that will be fixed. So this line 21 now says the municipality may allow for the imposition of a special assessment to secure private financing for, on page 2, property owners for these projects. So that's the first change, as Senator Watson just said, that the municipality may impose a special assessment as opposed to incur indebtedness. Question?
Yeah, maybe this is in another part. No, let me just keep mulling, sorry.
So I can walk through the whole document if that would be easier. I just wanted to talk about your time because.
Yeah, I am getting a nod for the whole document. Yeah.
All right, so back on page 1. So to remind you, section 1 is establishing a new subchapter. This is making it a subchapter specific to the commercial PACE program. The existing PACE program is in subchapter 2, and that is just for residential properties. And so this first section, 3275, is very similar to the section that exists for residential programs, but some tweaks have been made to it. So on line 11, this comes in the subchapter district means a property assessed clean energy district. The legislative body of a town, city, or incorporated village may submit to the voters of the municipality the question of whether to designate the municipality as a property assessed clean energy district. I wanted to flag here, I don't know what your intent is here. This process already exists currently for residential programs. So I was wondering if a town had already voted to have a residential program, do you want them to go through a separate vote process specific to a commercial district? So that's a flag here, because this is vague.
That is a good question. I guess I would also, we haven't got to the next paragraph yet, but I am wondering if we're not putting the full the credit of the town on the line, then do we need to have a vote of the populace? Can it just be a vote of the legislative body?
So I don't think so, but I don't know.
Okay,
And this actually gets to another like big issue in this, which is the mechanism that has existed for this previously was a special assessment
Mhm.
run by the town under the statutory language for towns in chapter 87. And so if you're taking them out to that much extent, is it still a special assessment?
or do we call it something else?
Yes.
I'm open to calling it something else.
Well, if it is something else, it shouldn't even go in this part of statute.
That is very interesting.
So. I'm slightly still unclear the amount of. Interface the municipality actually has in this,
Mhm.
or if this is fully just a private mechanism.
That is the intent, but it passes through the municipality.
Okay, so
But why does it have to pass through that municipality?
Because it's collected at the same time as their taxes.
So essentially, we're just having the town be the debt collector?
Yes, and it does, the intent is it creates a lien that would show up in property records. If someone was to try to buy a property, or if if they don't pay their debt, then at the time, look, this is getting a little further into the weeds, but just as an example, so if someone doesn't pay and there's something due, then all of that becomes due at the time of closing for the transfer, and future debts are not a part of that, but
Kind of like that taxes.
yes, and if the person sells, then the lien stays with the land, or the loan stays with the land and not with the person.
And
So there's a land records aspect to it.
so one of my questions was whether this would pertain to or could pertain to property that's owned by nonprofit organizations. Because if they are paying property taxes because they're nonprofit, they might have buildings that they want to use this for, whatever, but I don't know how that would work.
I don't know, I think it would. Because it applies to, there's later a definition that it applies to any building that is not residential. But so they could, but if they're not paying taxes, then we're paying property tax, nonprofits sometimes don't pay property tax.
Yeah, I mean, it depends.
It depends.
On the
Right, so if they're paying property taxes, then it would apply.
So just to go back before your question, it does sound like it is still going to be a special assessment because the municipality will be billing essentially.
Right.
So I think regardless of whether they already have a tax, they are that consenting to be assigned the special assessment. So that bill will come to them.
Okay. Then
But
I don't
we're
know.
deep in the weeds of things that aren't spelled out here.
Okay, so it doesn't seem like if we wanted to apply to nonprofits, then we should say that, because I'm just thinking as an example of a nonprofit in my district that just did a whole bunch of clean energy things.
Yeah,
And they could have
Yeah,
potentially used this, but I mean, it's an elderly services organization, you know, but.
that's a good point, and it, sorry, one more.
No, I just wasn't sure if they could, if they're not paying property taxes.
We should ask more about that, but I wonder if they could, as you're suggesting, even if they're not paying property taxes, if they could still get a bill for this special assessment.
Yeah, but I think it says in here industrial or commercial, and so we would have to change that, because
For nonprofit,
They're
it's not
building.
considered commercial.
they don't know.
No, they, nonprofit should be, because the only distinction in that definition is non-residential.
Oh, okay, I thought there was, of course, I'm getting ahead of myself, I'm getting ahead of you, Ellen, I'm sorry, so.
We do have one other question here.
Just General, I've been looking at this bill and I've been talking to people about it.
Yeah.
Did somebody put into one sentence or a paragraph the purpose of this bill? There's something ones.
Well, so the purpose of this bill is to allow someone to make energy improvements or resiliency improvements to a building that maybe they need a little extra financing to make it pencil out. And, or maybe they don't know if they're gonna own the building long enough to see the payback from an improvement, but they still think it's worth doing. And so they can make the improvement, and the loan that they took out to do it stays with the land and not with the person. So they can sell it and then they're not on the hook for the remainder of it. Whoever buys the land is on the hook for the remainder of it.
Thank you.
Oh, good. I'm glad that was helpful.
And it also would help make it make sense to do it, because it would enhance the value of the property, and you would make up your investment out of the sale, and the person would.
Yes, exactly.
So,
Yeah, no problem.
but I'm good to ask the question.
Nobody's gonna, that's not gonna able to clarify.
Yeah, yeah. Thank you. Yeah, onward.
Alright, still on page 1, line 15. In a district, only those property owners who have entered into written agreements with the municipality would be subject to the special assessment. So even though the whole town votes on whether to establish a district, only those people who have signed into an agreement are eligible for this program, so it's voluntary. Upon a vote of approval by a majority of the qualified voters in the municipality, voting at an annual or special meeting, it will be warned for that purpose, the municipality may allow for the imposition of special assessment. On to page 2. To secure private financing for property owners for projects related to renewable energy or eligible projects related to energy efficiency undertaken by owners of commercial or industrial buildings within the boundary of the municipality. And as we talked about before, we're just talking about in this chapter, in this chapter, commercial or industrial building means any building other than a residential dwelling. So I just came up with that definition because I was unclear to what specific buildings you wanted here.
I think
And
it's perfect.
the original chapter is specific to residential dwellings.
And we did talk, we had a little exchange about and appurtenances, just because that's first of all a fun word, but also.
I agree, that's that.
But as long as the appurtenances are a part of the residential dwelling, then it doesn't matter, because it's, I mean, because it's any building other than a residential building. So in my mind, I was like, oh gosh, so that means you could get paste for your shed. And I don't think that's the point. But that is a part of the residential dwelling, so I think we're covered. Thank you.
Yeah. So on page 2, subsection D, a municipality that has adopted a special assessment under this section may charge a fee for providing this service to a third-party lender.
Oh, this is to sweeten it. You know, like, why would a municipality do this?
Yeah.
They can charge. We have not specified how much that is here, but they're effectively providing a service to the third-party lender. They should be able to get a cut. Okay.
All right, section 3276, the written agreements, lender consent has been added as part of the title. So upon an affirmative vote of this section, and the performance of an energy savings analysis pursuant to the next section. An owner of a commercial or industrial building within the boundaries of a district may enter into a written agreement with the municipality that shall constitute the owner's consent to be subjected to special assessment. Entry into such an agreement may occur only after January 1, 2027. So this is still the proposed date, so to start next year. You can pick a different date. And then also wanted to point out that in the original version, the next sentence after January 1, 2027 was about the Department of Financial Regulation adopting underwriting criteria, and that has been taken out.
So you said, oh, DFR providing under, right,
Prior to entering into a written agreement, a property owner shall have the analyses performed to quantify the project's costs and energy savings. And on page 3, estimated carbon impacts of the proposed energy or resiliency improvements, including the following analyses. So, some slight tweaks have been made to this language from the prior version. You requested resiliency improvements.
yes, well, I'm wondering on page 3, at just line 1, if. Because it's the adding or resiliency, there is really modifying estimated carbon impacts of. Like the quantify the project costs, energy savings, estimated carbon impacts of the proposed. Oh, no, I guess I'm wrong, thank you.
And then the 4 that are then listed on page 3, they are not included in the existing residential PACE program. These are specific, these have been proposed to be specific for the commercial PACE program. Yeah.
Could resilient, is this pretty broad, the resiliency, could it be lifting a building up
Yes,
2 feet?
yes.
Yeah, okay.
So, and actually, I know I said I was wrong, I actually. Because the analysis is intended to sort of capture what the benefits are, or the costs and benefits. And so I actually wonder if we want to say, if the resiliency improvements should be like separate, right? Because it's costs, energy savings, carbon impacts, or resiliency
In the face of,
benefits,
yeah.
like as a separate thing.
It's interesting, but it adds another level of importance to doing this, because I had been sitting here thinking, yes, maybe it's solar panels, just get all
Yeah.
but here, this is something that actually benefits the entire community, especially if it's in a commercial area. And yet the owner may never see a return without doing this, it would take the gamble not to do it.
Right,
And it would never happen until it finally gets torn down because of flooding,
yes.
as opposed to making the investment. So, yeah.
And just to add on to that, in the conversations that I had, and we can have more testimony about this, but in the conversations I had, the thought was it's. Especially for resiliency projects, the intent is not necessarily to see a return, it's. There's other reasons.
It's return, it's an indirect return.
Right, exactly, there's a broader return,
Yeah.
yes.
So that's what I'm trying to understand. So if you have a special assessment district, property owner opts in, I don't remember what the 3276. They get assessed some amount of money. They never get that money back.
So the special assessment would allow them to enter into a CPACE agreement to get lending from a third party. That's paid back through their taxes, so it's a loan to the property owner to do some work,
Okay.
and then they're paying back that loan.
So the return is the interest.
Well, so right, like one possibility is that's for something like weatherization or solar panels, which does have a return to
But
the.
it's a loan, not a donation.
Right, it's,
Okay.
yeah,
And it's almost like the bank is making a loan to the property.
yes, that's exactly it, it's a loan to the property,
Property.
yes, yeah.
Is there any limit on the size of the project if it's solar?
That would be subject to any limits that are otherwise for solar.
So if it was in excess of, 50 kilowatt, it would pass 240, section 248.
Well, so you'd have to go through the normal unless it's portable solar, then you'd have to go through the normal CPG process. Yep, all of that still stands.
And there isn't a specific size limit on the type of project, but there is a cap. I think it functions as a cap that says it cannot be more than 90% of the assessed value of the property is the cap amount of the loan.
Yes,
And we were talking about having somebody from another state that's done that,
yes,
Tonka's.
yep,
Can we
yep.
Still do that?
yep, that is the plan. Okay. I've got a name. I think for next week, we'll see if we got.
Was that just starting?
Oh, no, it's okay, it's the New Hampshire guy.
Wow, we've not very far. Well, we had a break for
Actually,
like a minute.
yeah,
And we've had some big.
you missed the best part.
I'll just leave, you guys can figure it all out.
We're getting there.
So we're on page 3, so I'm gonna flag, based on that conversation that you just had, actually, I'm gonna add the word resiliency to page 2, where it describes the kind of things that can be, this money can be used for.
Amazing.
So on page 3 though, there are the analysis needs to be done before you can enter into the contract based on the type of project. So subdivision 1, if it's an energy or water usage improvement, you need to have an energy analysis by a licensed engineering or engineer or other qualified professional listed in a program guidebook. Stating that the proposed qualified improvements will either result in more efficient use or conservation of energy or water, the reduction of greenhouse gas emissions, or the addition of renewable sources of energy or water. And so 2 is for renewable energy, and then 3 talks about resilience improvements. So for whichever kind of project you're choosing, there is a requirement that you have an engineering study done to have them state that the improvement will result in some kind of energy or conservation measure, efficiency. Yes.
Can I flag a couple things? So one is on line 5, it references a guidebook. I think that gets referenced later about the creation or adoption of a guidebook. And there are guidebooks that exist out in the world, and so they wouldn't be creating it from scratch. They can, look at. Well, in fact, I think there might be one. Well, I have one, which it might be on our website. And then were you gonna note anything about line 17?
Sure, I didn't get there.
Oh, I'm sorry,
Yeah.
okay, I'm getting to.
So, there's a change on line 17, the rest of this was in the prior draft. So in subdivision 4, for new construction, you need to have certification by a licensed professional engineer or engineering firm stating that the proposed improvements will enable the project to exceed the energy efficiency or water efficiency or renewable energy or water usage requirements in the current building code. It also previously listed resiliency requirements, but you asked to take that out.
We can put it.
Well, because we were having a discussion about whether the things in the building code currently are identified as resiliency improvements.
Oh.
And I don't know the answer to that. I don't think they are, because we have a building energy code that is separate from the rest of our building code. This
Yeah,
is a small distinction, but I don't think that it's a huge impact.
yeah, I'm recalling that now because do we have resiliency standards in our code? I didn't think we did.
I don't know that they're identified as resiliency. I mean, there is some standards relating to flooding, but I don't know if they're identified as resiliency standards.
There are some things around flooding, design.
And I'm happy to put it back in. I just didn't want it to be unclear. We can make a note of that, come back to it.
Okay,
Then,
did you have another question on that or no?
nope, that was it.
I do have a question on this page. You were mentioning the program guidebook, but is that defined anywhere? It's called the program guidebook.
I don't think it is defined, but I think in the section on page 7, we haven't gotten there yet, but there is direction that if you should adopt this language and have a program administrator, they have to create educational materials for this program.
Okay,
And so you can be more specific, you can be as specific as you want.
and we can say, you have to create a program guidelines.
Yes.
Well, maybe, I thought we put that in, okay, if it's not in there, we should. We should put it in there, that whoever the program administrator is needs to. Adopt it. Okay,
Alright, so page 3 and page 4, so a written agreement. Shall provide that the length of time allowed for the property owner to repay the assessment shall not exceed the life expectancy of the project. On page 4, in instances where multiple projects have been installed, the length of time shall not exceed the average lifetime of all the projects weighted by cost. And so, previously, the language here, directed the efficiency utilities to calculate the lifetimes of such improvements, like what is the lifespan of a weatherization project or a panel, solar panel? That has been removed because efficiency Vermont is not really gonna get involved in this. But potentially, well, you may want to consider the program administrator will need to say that.
I apologize.
So, yeah,
So is this effectively trying to say that the loan shall see lifetime, the useful lifetime of whatever it is that's being done?
yes,
Which is also in its own way. Or even solar panels, half the cost of solar panels, more is the installation, it's the frame and the line run in and the rewiring, and so actually changing out the panels is no big deal, even though the panels have a limited lifetime, changing them is like not a big deal, it's you've made a permanent investment with the framework.
Actually, panels are minuscule.
Yeah,
Mhm.
so, anyway, I shouldn't have brought that up. I wanted to get on that.
It's a sunny level.
I apologize, I'm pitching up where we are.
we're up to the top of page 4.
Okay, top of page 4, thank you.
How would you like to proceed?
Oh, okay, so the way that we like to proceed, because we are not even close to being done with this. We, and we're gonna transition, to Mr. O'Grady, and we've checked out your schedule,
Great,
and so
I'm free
Would
for the
like-
rest of the week.
amazing. So I'd like to invite you back, for later this morning.
Okay.
To continue this walkthrough. It's a great discussion, so really appreciating that. And
It's actually pretty.
it's starting to like,
I have my.
okay, that's great. But we do have, Mr. O'Grady with us to walk through S213. So thank you.
Yep.
Hello.
Morning.
Good morning, welcome. We are so grateful for you to be here with a new draft of 213.
I do have a couple of paper copies still, I'm sure if you're gonna get to that. Should I begin?
Yes, please.
This is Mike O'Grady, what you have in, I'll let council, what you have in front of you is a draft committee amendment to S 13 and activating smart meters by public water systems. This amendment does 4 things. First, it replaces the term smart meter with the term advanced metering infrastructure device, which apparently is the proper term and was used in the previous definition of smart meter because there was, I talked to Maria this morning, at the time when they did it, they thought people wouldn't know what an advanced metering infrastructure device was, so they thought smart meter was more intuitive, but now I think the proper term is
Okay.
the second thing it does, it amends the cybersecurity requirements for public water systems. You may remember in the bills introduced, there was a requirement that as part of their permit, they demonstrate compliance with cybersecurity measures issued by the Agency of Natural Resources. I believe you heard some testimony that for security reasons, for prevent attacks, etc., that it's not wise to have your security measures public or part of your permit. And you will see a change on that, and then I have a couple of questions for you on that provision as well. The third thing it does is amends the metering requirements for electric companies. First, it changes the term smart meter to advanced metering infrastructure technology or device. And it then gives them the ability to charge for a alternative to a advanced metering device, wireless speaker device. And then fourth, it changes the title of the bill because it no longer is about smart meters, and it's not just about smart meters for public water system. So it's going to be an act relating to the use of advanced metering infrastructure devices. So those are generally the four things that it does. The stepping through the specific changes on page 2 in the definitions for public water systems. The term page 2 line 17, the term smart meter was replaced with advanced metering infrastructure device, and wired smart meter and wireless smart meter were replaced with wired advanced metering infrastructure device or wireless advanced metering infrastructure device. Similarly, page 3 lines 1 and 4, the term wired smart meter and wireless smart meter were replaced with advanced metering infrastructure device. Then there was a conforming changes on lines 1, 2, 5, and 6. It had previously said means a device using a fixed wire. We don't like to use device in the term and then again in the definition. So device was changed to equipment in the actual definition. Page 3, line 15, you're moving into the permitting requirements for public water systems. This is the language that says that the public water system requires a user to install a meter to measure usage. They may install a wireless advanced metering infrastructure device, provided that they have to give a written and prior written notice to the user, indicating that the wireless device will use radio or other wireless means. And that they, page 4, line 4, allow the user to choose not to have that wireless device installed. Provided that the water system may charge the user for the cost of the alternative device and any additional service charge required for public water systems to operate. So that additional charge is not changing for public water systems. It will change under the electric companies and what they can do. Page 4, line 9 to 11. This is just changing the term smart meter from wireless smart meter to wireless advanced metering infrastructure device. And then page 4, line 12 through 17. These are the cyber security measures. Remember, in the bill was introduced, part of the permit was that the public water system had to demonstrate to ANR their compliance with cybersecurity measures. And those cybersecurity measures were part of the permit. Permits are public. And so conditions of a permit are also public. So I believe you are concerned about making that type of information public. Instead, the Secretary, after consultation with the Secretary of Digital Services, issues guidance to public water systems regarding the implementation and administration of industry appropriate security measures. And then in the language that Senator Hardy sent me last night, there was kind of this not quite a requirement, but it's sort of a directive that the public water system consult with ANR about the guidance. And well, guidance is guidance. If you require them to do it, it's not really guidance anymore. And so I would leave that out, and that's why that language is gray. So I think having ANR after consultation with ADS issue a standard for guidance, that becomes the standard for the public water systems. If they're implementing that standard and there's a breach or some other failure of technology, etc., they've met the standard. They're not negligent, they're not liable, they've done what they could. And if the public water system doesn't implement the standard, well. Then they're on the hook, right? If they're not complying with cybersecurity measures, if they're not. Doing what they need to do to prevent breaches or other issues, then. That will be on them. And then that's something they already know, because they deal with liability every day, right? If they mess up, if they put too much of one chemical in the system or not enough. They can harm people, and so that's something that they manage every day.
And I was gonna say, just so you know, I've been communicating with Secretary Denise Riley Hughes at ADS about this and how much we should or shouldn't say. So I told her I would send her this this language just to make sure that they felt comfortable with it. Is that?
Yeah, it's great.
Yeah.
Well, I do have another question on this language,
Yeah.
and do you want to make it confidential under the public records?
I would say yes.
The guidelines.
Yeah.
Yes.
Yep.
And so do we need to? So I guess we would say that explicitly, that
Yes.
this is exempt, the guidance that is issued is exempt from
Right,
employees.
guidance issued to public water systems by the agency shall be exempt from inspection and copying of the public records.
And right now, I'm wondering if any other guidance that ADS is providing for people, if that is exempt as well.
There's a provision in one VSA 317C that gives ADS. I can't remember the exact term that's used, but basically they have a public records act exemption. You could say it's exempt under that, or you could say that this is specifically exempt. I can work with Tucker Anderson, as our public records act officer, to get the proper.
The other thing that I would add, and we're gonna hear from Neil Kamen, later today, so we can ask him to comment on this. And then, so just flagging out, I'm wondering if it's, because right now it's the secretary in consultation with ADS. I wonder if that would be flipped, but I don't have strong opinions about that. Oh, that's tomorrow. Thank you.
My point on that is that this is A&R's permitting program, and they provide a lot of information to these systems to operate, updates, training, etc. So that's why it's A&R providing the guidance, because they'll more readily have contacts with the system.
Yep. Any other question here?
I had an acronym or ADS, not sure.
Oh, Agency of Digital Services.
Oh, okay.
Yeah, sorry, I was
Thank you.
contradicting.
Sorry.
Okay.
So
Oh, another.
We want parallel provision for electric situation.
well, there isn't that directive for them to issue. Well, are you asking, should there be a directive for guidance?
Parallel, it's not the same thing as drinking water, it's like.
But I actually don't know what you put in here with that, but what we heard yesterday is that the electric companies the utilities are heavily
That's what I
regulated
heard.
by both the federal
Yeah,
entities and the PUC, so that's kind of,
they're covered.
they're already covered, I think.
So moving on, you're moving into section 3, page 4, line 18. This is moving into the electric company provisions. First thing, it changes the title of that section from smart meter to advanced metering infrastructure devices. Changes the terminology, the definitions as well. I won't walk through all of those. It's the same change as what you just saw in the public water system. The big change is page 5, line 20, 21, going on to page 6. This allows them, or allows the customer to choose not to have that wireless advanced metering infrastructure in place. And it strikes that provision that said at no additional cost. Provided that the electric company may charge the customer the cost of all of the alternative devices in addition to service charge. Required for the electric company to operate the alternative. But I talked to Maria Royal, who's our utility electric utility expert, whether or not this will become part of the formula of tariff rate. She doesn't think it will necessarily become part of the electric rate, but it'll be something that the PUC will likely approve the amount of.
Yeah, that's what they were saying yesterday, that each electric company would probably have a different charge and go into their filing to the PUC for approval.
But not necessarily as part of everyone's rate on the bill in that company service.
Right, it would just be for people who are opting out, yeah.
And then there are additional changes in this section. There were 2 reports that were due over 10 years ago. And that have been supplied. They've been kept in the statutes because of the fact that questions about them arise. We're gonna strike them, we're gonna repeal them from statute, but we're gonna put them in the statutory notes that are in the green books. Generally, anytime a report is more than 5 years old, we get rid of it under the reason to keep it. Now, these are over 10 years old and we can still keep the reference to them in the notes so that anybody that needs to see that can see them. And then the last change is on page 7, line 17 through 18, changing the title of the bill. So it is no longer inactivating the smart meters used by public water systems, and it's now inactivating the use of advanced metering infrastructure bills.
Okay,
And this needs to be edited. I didn't have time for the
it
edit.
was okay. Well, thank you. This is great. I think the only thing that we have yet to, I mean, I'm comfortable with all of this. With with a pin in what we do about the cybersecurity.
Yeah, I'll
Yeah.
send the draft to the secretary and have her take a look at it.
Okay,
I'll consult with Tucker about how best to make that information confidential.
okay, amazing. Otherwise, I think this is close to baked, which is very exciting. So thank you so much.
You want me to hang out for 224 or?
Let's see.
Yeah, let's see.
Yeah, I will leave that up to you.
Okay,
No
I
pressure to stick around.
have another fire burning in my house.
Oh dear, okay. Good luck
Thanks.
with all the things. Okay, so I actually would love to take a quick break, if that's okay. Yeah, before we jump into All right, and we're back. Okay, great. This is still Senate Natural Resources and Energy. We're back from a break, and we're taking up S 224, broadly speaking about lakes, and we're joined by Mr. Covey from oh gosh, I'm gonna get it wrong. The Vermont Transitions Coalition. Welcome.
Thank you, and happy Vermont Outdoor Recreation.
Yes. Yes.
I think it's very fitting that I sit here to oppose sections of this bill on outdoor recreation today. Regarding sections 1 and 8 of this bill, they're both non-starters for us. This issue closely mirrors the discussions we had surrounding Berlin Pond that began in 2012. At that time, access rights were affirmed, courts upheld the validity of that access. And the reason this body is revisiting an issue that has already been settled is clear, but it's not particularly appropriate. The city of Barre doesn't own all the land surrounding the reservoir. Access exists from the public right of way to the public water where the mean high water level intersects the road right of way. Assertions to the contrary would be incorrect, so the bill's flawed in its assumptions and won't satisfy a single complainant that it's been drafted and modified. There were certainly more constructive ways for this conversation to be initiated than the approach that was taken. And it's unclear whether any of those alternative pathways were explored prior to provoking the current dispute. Regardless, the fundamental fact remains unchanged. It's a public water body to which the public is entitled access. It's generally a bad idea to create legislation for the edification of a single individual, and this is no different. There are always gaps that don't satisfy the person screaming loudest, and there are always unintended consequences. Several facts demonstrate the impracticality of a municipality fully constraining the inputs to the Dick's Reservoir, which we all know is the impetus for this bill. It's been pretty clear. Roadways to the north and east borders of the reservoir render anything short of constant monitoring ineffective in managing genuine threats to the water. The stream connecting the upper and lower reservoirs runs approximately 1.5 miles from dam to intake and passes through private property that appears from aerial imagery to include agricultural fields. There are 5 separate inlets that feed the reservoir, all of which traverse private land. Approximately 5,600 acres drain into this water body, and only about 500 of those are under municipal control. The reservoir is a popular layover for migrating waterfowl, which are natural vectors for aquatic invasive species and contribute significant biological loading through fecal deposition. Aquatic mammals, also including otters and mink, move freely throughout and between watersheds and are capable of transporting biological material. And again, the intersection of the public right of way and the mean water level provides lawful access irrespective of the city's state position. Concerns have been expressed regarding zebra mussels, which, while understandable, are not supported by the available evidence. Zebra mussels were first documented in Lake Champlain in 1993 and in Lake Bomazine in 1999. They're planktonic larval stage villagers, the mechanism by which they spread. So villagers have been detected in Lake Carney, and similar detections have occurred in Lake Dunmore and Lake Portonia, but they didn't result in infestations as the mussels can only persist and survive in the correct conditions. In 2011, 10 samples taken from Lake Carney detected no villagers, so this was a year after they were detected. In 2012, 4 additional samples again showed none. In 2016, 26 lakes deemed high risk for infestation were sampled. No villagers were detected. So in light of these facts, a continued emphasis on zebra mussels as a justification for denying access is for practical purposes unfounded. Potassium permanganate, I may get this wrong, permanganate is a widely used chemical in water treatment. It's a strong oxidizer that removes iron, manganese, and hydrogen sulfide, and it improves taste and appearance. It's also effective against certain bacteria and algae, and it's lethal to zebra mussels. So this is how the city of Burlington deters them from being around their intakes. They inject it directly at the intake rather than further downstream in the process, and it alleviates the problem. Again, the zebra mussels aren't a really practical concern here, but if they became a concern, I'm willing to bet that that chemical is being used for the city of Barre as well. Milfoil has also been raised as a concern. Berlin Pond contained milfoil prior to public access. And as we heard from Senator Williams, Rutland's Reservoir, which is a man-made system with all of the inputs completely controlled by the city, has a milfoil problem that they're currently dealing with. Very safe to say that humans weren't the vector there. Public access to Berlin Pond has existed for nearly 14 years at some level without negative outcomes. So there's no reason to expect a different result at the Dix Reservoir, or any other water body for that matter. As always, ongoing education, not prohibition, is the correct answer. Going to the extreme of granting municipalities the authority that's currently exercised by DEC and setting this dangerous precedent is not a proper approach. From a practical standpoint, the bill as written would theoretically impact 11 water bodies statewide, to my understanding. This raises the question of which municipality would be next to seek authority over their water. And it's reasonable to expect that Montpelier, which owns virtually all the shoreline around Berlin Pond, would show up next. Extending this logic further, nothing would prevent other groups, such as private landowners who collectively owned all the land around a water body, from requesting a similar privatization of access to the water. There's really no reason for this, and again, it attempts to override laws that protect public access to public waters, and for that reason alone, if it continues to contain these two sections, it should not advance. The constitutional guarantee of the right to hunt, fish, and fowl doesn't fall under the legislative authority to change, and in fact, the legislature is explicitly prohibited from changing it by that same document. Although I recently heard legislative counsel indicate that you can help circumvent the law, I think we should all take a pause and think about that for a moment. This body is charged with keeping and developing the law for the good of the people and should certainly not be seeking ways to circumvent it. It's demonstrably counter to the public good to begin reducing access to fish and game. We have a great display going on right now up in the card room where they're talking about food security and access to fish and wildlife is an excellent means of enhancing food security statewide. The constitutional guarantee of the right to hunt, fish, and fowl, again, is critical. Allowing municipalities to promulgate surface water rules represents a significant overreach and sets a dangerous precedent. The Department of Environmental Conservation is already charged with this responsibility. They've implemented surface water rules for this reservoir, including the prohibition on gas engines. Additional regulations are unnecessary and it relies on a false narrative of undue risk. Both the city and the legislature should refrain from further action on this and allow the tournament as well as general access to proceed. Communities are better served by municipalities that act as good neighbors than by bureaucratic efforts to restrict legally protected access with no scientific justification. The use of law enforcement to discourage or ticket individuals who will likely be accessing these public waters mirrors tactics employed by the Berlin Pond dispute more than a year ago. Our approach was inappropriate then and remains so now. Law enforcement resources are better directed towards genuine public safety concerns, not disputes over lawful access. Vermont's home to approximately 120,000 anglers, and the consequences of this proposal would extend statewide. Claims that participants would need to parachute in to be lawful or inaccurate, as I've noted several times already. And directing law enforcement to trespass individuals who legally access this waterway risks a violation of citizens' rights and exposes the municipality to potential legal liabilities. A water supply must be capable of handling the range of internal and external inputs they encounter. Anything less is irresponsible. Recreational water access and drinking water supply coexist throughout Vermont and across the nation. Lake Champlain's condition is well known, as is the fact that water drawn from it is delivered safely to households across most of our western border. Concerns expressed regarding the adequacy of the city's water treatment process should be addressed directly by taking care of them rather than projecting them onto the broader public. This water body already receives runoff, biological waste, heavy metals, and organic matter from areas beyond municipal control. The water travels approximately 1.5 miles from the reservoir that we're talking about to the actual intake. And a significant portion of this, again, runs through land that's not controlled by the city. Furthermore, there's no evidence that fishing access has caused harm elsewhere, and there's no reasonable expectation of illegal do so here. While some members may desire to act on this, the proposal is untenable and warrants no further consideration unless these two sections are removed. Finally, the section requiring permission to cross private land for the purpose of participating in a derby is inconsistent with Vermont's constitutional provisions. Unposted land is open to hunting and fishing by constitutional right, and imposing a requirement to seek permission for a single day will create confusion, burden lawmakers, burden landowners, and increase conflict rather than reducing it. There are longstanding access routes used seasonally on many water bodies that would be disrupted without justification. There's one pond in particular, they have a one-day fishing derby. that pond has probably 10 or 12 trails across land, private lands that access the pond from around the perimeter of it. And to say that could be used on Friday. It couldn't be used on Saturday without permission, and then it could be used again on Sunday. Doesn't make a lot of sense. You're gonna have landowners who've never had any issue with it. Getting flooded by phone calls over something that's constitutionally questionable. In closing, these provisions disregard the Constitution, public trust doctrine, and the Sportsman's Bill of Rights, all of which protect access to public waters and unenclosed lands. Treating the outdoor community as second-class citizens has no place in this building. The municipal treatment plant can address modern water quality threats. It can accommodate the negligible impact of recreational access as currently permitted. If it cannot, then its existing deficiencies should be addressed independently of public access as a matter of public safety and the public good. Grandstanding about a nebulous spread of recreational access does none of that now any more than it did in 2012. So I urge this committee to either remove these two sections or barring that, pin this bill back to the wall and move on to something meaningful.
I have so much to say about that. Oh my goodness. Okay, where to start? But well, I guess I'll start. Did anybody else have questions, comments, thoughts?
We don't have that question.
Oh, it's just something to see.
You will.
Okay.
Good.
No? Yes, if you want.
Well, I'm still mulling, but. if you
I can
wanna
go, I can go.
Yeah.
Well, so I have two main places I want to start. So one is you have made some assertions about the law. And I'm wondering if those are coming either, like, if you are a lawyer or if that's coming from your, like, if you have some kind of counsel that could speak to that.
It's coming from over a decade of dealing with this issue. Berlin Pond was my inaugural issue.
So, but you're otherwise not a lawyer on that. Okay. So that's good to know. And then the second question I have, so I'm trying to find the, like, what is the common ground here? If I didn't reach out to you ahead of time, I apologize. No offense was meant by not reaching out. You mentioned alternative pathways and that apparently none were sought. What alternative pathways could you envision?
I don't know. I know that this came about because an individual decided they were going to access the pond, right? And they applied for a fishing derby. I don't know if they had conversations with the city manager or anything like that beforehand. I'm not sure what that was.
Our testimony was that the city manager was only made aware of this situation after the tournament, permit was approved.
Right. So my point is that while that could have been done differently, it wasn't, and that access remains legitimate. Regardless of whether or not it angered the city management. You know, it's disappointing that it wasn't done a bit more thoughtfully, but that doesn't change the legitimacy of it.
So do you see the conflict there though with the concerns about about the safety of drinking water?
I don't, you know, as I stated in my testimony, if they are concerned that they have insufficiencies in their system, they should be addressing those insufficiencies, not prohibiting access.
Well, and the testimony was that it would be millions of dollars to upgrade. And so that just flagging that. And then another, something else I was gonna ask you about. You mentioned the zebra mussels. I will just say that was my question to city manager. That was not his main objection. So understood. And don't know if did you call it sodium permanganate?
I believe that's what it's called.
Okay, so, you know, we can follow up to see if they already use sodium permanganate. Be interesting to know that.
My understanding is that it's very common because it improves the flavor and I believe the clarity of water.
I'll just also flag, there was a whole lot in there that I disagreed with. However, I would also say, like, if there are alternatives to where we can both protect drinking water and allow people access to fishing, I'm game for that Venn diagram. Would love to hear potential solutions at some point from you if you have them.
Well, I think we can all agree that there are very real threats to drinking water, right? I don't think we can agree that fishing access is one of them. And I hear the concern that it might take millions to upgrade their plant. But if it takes millions to upgrade their plant to a space where they can protect against whatever threats may come, which this is negligible at best, if it's even a threat. That's their responsibility to their citizens, correct? Would you agree?
I think they are managing to the risk that they are ready to accept. And this was beyond the risk that they were willing to accept. But I think there's, do you have another question?
Me,
Yes.
yeah, thank you for your testimony. I would say, first of all, in the future, please don't bring our legislative council attorney into your testimony in the way that you did. I don't think that's fair. He is a nonpartisan employee that does what we ask him to do. And we are the ones that make the laws. And if we ask him to try to help us make the laws, he's doing his job. So just in the future, just please keep Michael out of it. Thank you. I'm specifically interested in, I don't know these bodies of water because they're not in the part of the state that I'm familiar with. So it's hard for me to kind of visualize. And I heard the description of the pond. What is it called? The one in question?
Oh, Dick's.
Dick's Reservoir. You said that there's not gas powered boats are not allowed on it, correct?
Yeah, you received that testimony from DC or Fish and Wildlife.
Okay. Do you know, I mean, I know these are not your fishing tournaments, but do you know the two in question? I think there's one maybe like next week, a ice fishing tournament, and then one in the summer. Do you know how big they are? Like how many people they are? Okay.
No connection to us.
Okay, cause I'm just thinking about, I understand your concerns about precedent that section 1 might set. But I'm interested in section 8 and whether or not we can come to some kind of language that would be okay, mainly because it seems to me that when there's a fishing tournament, it's not just, a few people going out on their boat and fishing, it's a lot of people. I mean, like that's a tournament, right? It's a lot of people. Or it could be a lot of people. It could be a lot of people. And if it is, the testimony that we received was that the city wasn't aware of the fishing tournament until after it was approved, which seems kind of uncool to me. Because it could be hundreds of people. I mean, if it's only 10, 12-year-olds out there ice fishing, that's not a big deal. But if it's hundreds of people coming in with trucks and in the summer boats or in the winter snowmobiles or whatever it is, then that's like a bigger issue. So it does seem like some kind of communication mechanism is at least the right thing to do for everybody. And I'm not saying that it would lead to denials, but it would lead to better communication so that there's not conflict. And I also, feel for the parking, because everybody drives to these things and then there's like a ton of cars and trucks, parked around the town's drinking water, and that is at the very least problematic from a public safety perspective, if they're not parked in places that are legit. So it seems to me that on this section, we should be able to find a way that we can improve the communication, that the municipality or the landowner doesn't come, the municipality in this case is the landowner, but that landowners don't come out of after fishing tournaments having a lot of cost, a lot of headache, and having surprised, suddenly 500 people show up or 100 people show up to fish on there. Yeah, so that's what I'm trying to figure out, is a better way to communicate, and whether it's notification, permission, compensation for costs, there's gotta be something that we can do so this doesn't keep happening. You yourself have admitted this is the second time in your time doing this, that this kind of thing has come up. So how can we prevent it in the future? It seems to me that better communication is the way to do it.
I think the best preventative would be to acknowledge the fact that fishing is not disruptive to public waters, it's not problematic. The new section, section 8 that allows town managers to charge for costs. What does that entail? I mean, that in and of itself is a good way to ensure the fishing derby season again.
Yeah, I mean, I think this is big, but I mean, I'm trying to figure out like, how can we, and this is not just about this one section. Or this one town or one incident. Because you're, in your testimony, you talked about how this has happened in the past, so how can we make sure that there's enough communication and there's enough back and forth so people are not surprised?
I think that being surprised is an intriguing way to look at this. So, and the reason for that is we have fishing derbies all across the state, right? So what makes these water bodies special? Nothing in particular.
Well, they're drinking water, that, I mean, that's,
So is Berlin Pond, I believe Waterbury Reservoir, Waterbury Reservoir has motorized recreation. I mean, I don't see a need to. I don't see it reasonable to say that the town has authority they don't have or needs notice they don't need. Because it's not done so anywhere else. I mean, if we're going to do it for Dick's Reservoir, then why not do it for Casting? Why not for Lake Champlain? There's no logistical difference.
yeah, I mean, I would agree, so that's why I'm saying, maybe notification just in general, like, hey, we're gonna have a fishing tournament, you live near here, maybe you should know. And people, it doesn't say you can't do it, but just that there's notification and that, you know, people are aware that it's happening and measures can be taken to make sure that damage isn't done. And I mean, I know, and the vast majority of these are, nothing happens and, you know, bad and everything is good and people have a lot of fun and they're a great thing. Believe me, I'm just suggesting that there are instances where we could avoid conflict by having better communication. I mean, that's just in general in life, I mean, that's.
So I agree that the communication on this should have been better. I'm not disagreeing with that, but I just have real, have real concerns over the concept of requiring permission to access public lands and waters. They're public, we have constitutional rights to access them. We're in a space as a society where we're trying to ensure the most equitable access possible. And when we start putting barriers in front of that, we immediately start reducing that.
Yeah, I mean, I completely agree. I think access to public lands and waters is incredibly important. That's like fundamental, and it's frankly disturbing to me that we are seeing more and more people say, no, you can't come on my property, even for just like walking across it. I mean, if you go to other countries, there are public trails across, you know, gorgeous fields that everybody uses in their private land. So I agree, we should have more access to the land that we all love. I'm just saying that in these instances where there is potentially lots of people accessing a body of water that is important and fragile, that having better communication and notice so preparations can be made and, you know, adjustments can be discussed is important.
I don't have an answer, and I don't think you have time for me to develop one right now, but
Well, think about it, mall.
I will know. But I'm pretty firmly entrenched in the idea that the constitutional right to public access to public lands and waters is very direct, specific, and important. And it doesn't require permission.
But does it require communication?
This is.
Okay, go ahead, we have, Senator Rick, and then Senator Beck.
Legislative council, but don't we already required to notify the Fish and Wildlife Department of fishing derbies?
Yes.
So maybe it's just a, complimentary cursory. Hey, oh, by the way, this is going on in your town, scheduled for this week, because I know I tried to get. Permits from the state for fishing derby in my town. Sometimes it takes a couple weeks to get it. You know, if you add another layer on top of it to notify the municipality, maybe we're already notifying the state. can't we, let's have the state or the promoter of the derby notify the town that they're having?
Does it become a notification or a request for permission though, because there's a distinction?
Go ahead.
Just, maybe I'm just trying to word for example here, but I've never been to Dick's Reservoir, I just pulled it up on Google Earth, I'm looking at it. I don't see any docks, I don't see any boats, I don't see a boat launch, so this is just,
It's our top one.
from shore. Okay, fair enough.
And the city does control most of the land around,
I do see a few houses.
directly around it.
Yeah, spillway.
But where they don't control is, so there are multiple inputs, I think 3 of the inputs run under roads, and then the stream that runs between. The water body where people want to fish and the actual intake runs again under the road on its way to there's not much space between. Where the road passes over the water and the actual intake.
Yeah, it's right there, I mean,
Yeah, so.
So I just want to put a pin in that they don't control it, that they don't control all the land. That is a question that I think our legislative council, he actually has weighed in on. So I just want to flag that as a term.
But
Yes.
I just thought another thing too, is that. Do we have to, it may probably for legislative council, do we have to. Notify the Fish and Wildlife Department to get authority to have a fishing derby? Then is there a constitutional question about that?
I'm not sure, you should probably talk to DEC and Fish and Wildlife about this, I'm not sure exactly what the mechanism is there, because I've never done it. I don't know if Fish and Wildlife consults with DEC before, providing a fishing derby, opportunity. Before providing permit, I'm not certain how that works, that would be their development.
One further question about the potential for a charge. I'm thinking about examples where like you host a marathon and you need extra police protection for, the marathon runners. Then that tournament ends up paying for, or the marathon ends up paying a little bit extra to the police department for that extra incurred cost. Can you comment on why, because I'm assuming that you're opposed to any charge that the municipality could have for a fishing tournament. But I'm wondering why that might be any different than, say, a marathon.
Well, for one, I think that the promise of sending officers there and complain about the cost of it. I feel it's unnecessary, that's a decision the town is making, and that's on them. I feel it's a municipality flexing against the citizens of the state in a manner that's inappropriate. I think it takes law enforcement away from meaningful duty and puts them into a conflict that is unnecessary. But furthermore, with the comment or the new language in there that says that the manager can charge for the expense of mitigating the cost. Well, man, there was a kayak on my lake and now I need a home and water system. That's the logical, that's absurd, right? But it could go to that point. There's no guardrails. And I think it's not particularly meaningful, but I do think it's incredibly restrictive.
Okay, any further questions?
Well, I think your example is a good example of like anytime you have any kind of public event with lots of people there, often. Having, some kind of security or law enforcement is helpful and those kind of events do cover the cost of that because they're beyond the sort of normal grouping of people. So I think calling up examples of like one kayak on your pond and you have a need a new water system, that's just exaggerating like that. I don't think that's a fair retort. But I do think that being able to cover the cost of what the event incurs is helpful. The question is, what does that mean? What's the definition? I agree that if we need to get clear on that, but.
Well, we don't see law enforcement presences directed at any other fishing derbies. This is a municipality making a decision to flex against an event.
And there's not really any getting around.
Hey, any further questions? Thank you very much. Okay, we're gonna transition to Mr. Putnam. Welcome.
This is the same bill.
This is the same bill, but I believe maybe you're speaking to a different section. So
Variety of things.
there's a variety of things.
Yes.
Thank you.
Yeah.
Amazing. Thank you for being here. The rest of this is, so, okay. Thank you. Welcome.
Thank you for having me.
Yes.
Appreciate it.
Yeah.
My name's Robbie Putnam. I live on Lake Iroquois, Pine Zone. My parents are primary home. We moved there in 2015. My daughter and my son lost son now, but so we're a family of three now. Wanted to, I guess, sorry.
You're good. It's all good. No worries.
So the Homeland rule part of this, I believe, was one of my primary feedback on. So the backstory, so we bought our boat. We've been boating our whole life. My wife and I got married at Burlington Boathouse. We used to boat on Lake Champlain. We'd spend 10 days all summer. Went to our wedding by boat, left by boat. I've driven lots of different boats in my life. We love boating. Keeps the family together. There's no Wi-Fi. We love. So we moved here to boat, beyond the lake and enjoy the lake, whether it's in all kinds of uses. So the home and lake rule, I'm not opposed to as a boat owner. There was a lot of Eurasian milfoil on Iroquois, so I don't like invasive species. I'm all about keeping the water clean as best as possible. I'm all for that. My boat doesn't leave my front yard. I see my trailer twice a year. My boat goes from, it's on a lift, so it's not even in the water. It's so 90% of the time it's elevated above the water line. I get it serviced at the dealer in Snre, New York. So every September, October 1st, it goes to New York, it gets winterized and it goes into a barn, and then it comes to our lake, and that's copy paste for 10 years. So the one thing there's a ripple effect of some rules that are in the mix here. And if I can kind of reference this, out of the last rule change, I got Civil app. And this is a chart of Lake Iroquois. And this is as the rules say. You can pass that around, it doesn't time out. But basically that's, I keep it on my dash right in front of me. It's captaining my boat. It shows me exactly where I am. So I know where I am. Oh, that's my daughter. Thank you. She started surfing at 9. So.
But just so Ann knows what you're doing, showing.
Oh, yeah.
So
That's like,
that's
this is
that's where you can go.
the dark blue is where I'm allowed to be.
Okay.
So why I'm always aware of where I am on the lake, and I stay within that boundary. There's a proposed change that wants to go from 50 to 100 acres, and then also have a 3,000 foot straight line. Tip to tail, if I use the scale of the chart, this is a 4,000 foot path. And to kind of shift back for a moment, Lake Iroquois has lots of users. From there's a water ski course at the top of the lake, and obviously those guys love the house, like what we call it the house of glass. They want to ski first thing in the morning and late, and there's no wind.
Yeah.
So when there are other users out, we stay away. If there's guys water skiing at the top of the lake, we stay at the bottom. So this area, I can, it's where I'm able to be. Most of the time, I'm only using half of that space because there's other users, and I'm respecting other boaters or kayakers or fishermen or such. And so we adapt there's another number out there that of all the boats in the state, there's only roughly 300 or like 1.5% that fit this category. I I geeked out and if, asked ChatGPT, if you, what's the amount of daylight hours from May 30th to October 1st, and it was like 1,350 daylight hours. I only put 25 hours on my boat. And half of that time, you're kind of taking a little putter around the lake, or you're getting to where you're going, so the amount of time, that breaks down to maybe an hour a week. So I think there's been, we're super respectful, and if I'm only out there an hour a week, I'm not keeping other people from using the lake. I think we're very respectful to keep our distance and move and shift as best we can. Lake Iroquois, of all the users, we even have a text chain. If we see an open water swim around the lake, the texts go out. And sometimes you feel like if you see somebody out doing that, you feel like I can't leave until they're off the lake, because we've actually gone out and pulled people in, so. It's the give and take and the compromise and the share, but back to the home link rule, I'm not opposed to it. But I'm also, because I'm kind of not affected by it, other than if this all were to change, I don't have time in my life. I've got a career, my wife's got a career, we're busy. I don't have time to go to work. So this isn't going to force me to do one of two things. Either use my boat in a non-serving fashion, or non-ballast tanked engaged session, just use as a regular boat, or sell it. But if this goes into, so I don't have the ability in my life to trailer someplace else or go. So it's just, it's going to force me to take a loss on an investment and find something else to do. So.
Go ahead. You're.
I'm sorry.
No, you're fine. You're doing great. Thank you for taking time. You're fine. I'm a little confused because if you don't go to another lake with your boat, I don't think it would affect you. Because
Right.
it's only if you take your boat to another lake that you would need to get it decontaminated.
Right.
But if you only stay on Lake Iroquois and then put it in storage in the winter, I think you're good. Like,
Yeah,
so
I'm not, again, so it's, it doesn't affect me in a sense. But the ripple effect of it is it does affect me if the second rule or this modification of the rule gets.
what is the second rule?
So
Is that in the bill? I don't remember it. That's fine.
If I'm understanding, forgive me if I don't wanna,
Oh, I like this.
No, what I think I'm hearing from you is just so separate from this bill, there's a rulemaking process underway that's gonna change which lakes are eligible for wake boats. The restrictions on the border, I'm losing the right words, but like thank you, the distance from the shore is changing, and maybe the acreage or something like that.
The minimum acreage is the biggest.
Yes, and so what I'm hearing is that Lake Iroquois, either the amount of area available is becoming smaller for wake boats, or it's becoming ineligible.
It'll be ineligible.
Okay.
So it would, if I wanted to do it, I would have to go someplace else. So then it would affect.
Okay, I didn't understand, because I don't think
Doesn't affect me
it's not
now.
in the bill, it's in
But
the rule that's being proposed by the department.
Right.
I see, okay,
Yeah,
I see.
so you could say it's a non-issue now, but it could be a big issue. It would be a significant issue for me, like take your right now.
So, well, I also don't wanna jump in, I am assuming what you're asking is to look at which lakes are eligible. Or,
Well, there's also, I guess it's a broad swath that's going across the whole state versus, and I understand like each lake is unique, it has its own usage, and we're not a busy lake, we're pretty quiet.
yeah, you're right.
And it's, so yeah, it doesn't affect me currently,
Right,
but next year it would affect me 100%.
yeah, no, it definitely would,
I
I
go
was.
from 0 to.
I was confused because it's not in the bill that
Right.
we're looking at, it's
Yeah.
different, yeah,
Different
different, so yeah,
things.
okay, yeah, that makes sense.
And to kind of ripple onto, sorry. Those.
It's all good.
So. There's, my neighbor has a regular, like Snre is a very popular brand of boats. Yeah. He has a 22-foot bow rider, which is about as copy paste easy as you can, very common. So I have a 23-foot ski nothing. These two boats dry weight are almost within a couple hundred pounds of each other. So every boat that goes on the market has a yellow badge next to where the captain's helmet is, that says how many people you can put on your boat. So a couple times a year, my neighbor has a family reunion and they put, 10 plus people on the boat and do a 10-mile-an-hour slow, sightseeing cruise around the lake at just off the 200-foot line. Well, that's putting up
Hugely.
a wave that's comparable to me, and I'm 500 plus. So you don't necessarily have to have the activity to have the outcome. So I feel, not to go on a tangent, but I'm 1%, and of that 1%, I'm a 0.5% of that 1% being used of actually engaging in sport. So we're changing, and I'm being singled out in the sense of something it could be an everyday occurrence. So there's layers to the onion. And I think the biggest thing is compromise. And at voter education, my daughter took an 8-hour course to get her safety course. And so for 8 hours, you have to sit in a room and listen and learn the rules of voting. And not to be, but if you go to Dick's and buy a kayak or a stand-up paddleboard, you don't necessarily know the rules of the lake. And as much as the signage, we had some kayaker, the engine was off, we were coasting, we were just stand still, we were kind of switching riders and swimming for a moment. And a couple went by and it's fallen on us to educate people on the lake as far as the new rules. So I said, hey, just so you know, this is a space that we're only allowed to be in. And they said, well, how do we know that? And I said, well, there's a sign at the axis. And whether they see it or they don't see it, it's arbitrary, so it's, I've had times where we've gone out on the lake and there's a boat anchored in the middle of where we are. And so we putter up and say, excuse me, hi, and it's a sunny day everywhere. And I don't want to ruin your afternoon. Would you mind shifting over, so we can enjoy the space as well? And couple with this, they're like, yeah, have fun, no problem. And so it's just talking, it's back to communication,
Voting culture.
yeah, and it's if the lake's busy, and our lake is small enough that if there's literally more than 3 boats moving around, we don't go out. You just kind of pick your time, and I mean, obviously we live there, so we have the ability to kind of do that, but so boats trailer in, and they might swing around, but then they park and swim and hang out in the sun for a while. So it's kind of an ebb and flow of use and sharing and compromise.
Just a technical question, for a weight boat.
Yeah.
Do they have a different hull than just a regular, does your ski to teak have a different hull because you have ballast tanks than a ski not peak without?
It's my generation boat, so
Yeah.
mine's a 2014,
Yeah,
had the same hull as a prior
okay,
non-surf boat, it's kind of adapt. They have hybrid boats now that are, so if you're in ski mode, it's gonna make a flat wave, hopefully, not as pure as a tournament boat, but so it could be, it's been modified at times, I guess that's what to say, so, but the biggest thing is, it's ballast tanks, and then there's like Mastercraft uses what looks like a trim tab, Malibu uses what they call a gate that moves vertically. Nautique actually has like a 2-inch tab that kind of just creates resistance, and it doesn't change the size of the wave. What it does is it shifts the boat slightly a couple degrees, so it smooths out the side that the rider's on, and then puts the foam on the other side, so it cleans the wave up, but it doesn't make it bigger or smaller. So, and just because the boat has a tower on it, doesn't make it circular. So if you look across the lake and you see a boat going down the lake, there's no way to necessarily discern whether it's a surf boat or not, just because it has a tower. Or so there's a lot of. Unless you actually see somebody surfing. Not, I could talk to this, we could.
When you,
Yeah,
you have to register your boat and get a license for it, right?
Mhm.
Yeah, and do you, as a boat captain, and you said your daughter took a boat safety course, but is that required by?
Oh,
law,
yeah.
or is it?
yeah, if you were
Okay.
born after 1974, it's required that you have a boarding license.
Okay,
And you have to be a certain age too.
Yeah, I think 10 to 12, you have to take it in person, 12 and over, you can take it online.
okay,
But there's a captain of a boat, power boat, you have to have a license.
okay, that's good. Otherwise, I was gonna say, let's put that in here. When you register your boat, it's with the Agency of Transportation, yeah?
Indeed.
Do you have to say what kind of boat you have?
I think it's just length. I mean, when you register the boat, you fill out like you're registering your car. I think it asks for length, weight, maybe horsepower, but it doesn't, whether it's fiberglass or metal or such, but
Okay.
it doesn't, they don't ask that second
Okay.
question.
Cause I think one of the problems is, in addition to better communication, is better data.
Sure.
Like, we just don't know we don't know how many kinds of boats there are in the state,
Here's an
so,
example, like,
yeah,
that's in, friends of mine, the largest boat dealership up in Colchester. And I've asked them for years, how many boats do you sell? They said roughly we sell about 180 boats a year. I said, well, how many of those are surf boats? They said 1 or 2.
yeah,
And so, yes, nationally, it's a very big part of, the latest and greatest and probably movement, but
yeah,
in Vermont, we have a 3-month window
yeah,
and they're not cheap.
yeah,
So the ripple effect is there's not a lot of them here. We have on our lake, when we moved there in 2015, one of my neighbors, his boat was 2010, so they had been surfing for 5 years before we got there. There was 3 boats, I think, that fit the category at the time. And 11 years later, there's 3 boats that fit the category. One sells, one go, families kind of come and go.
yeah, so would you be okay with a requirement that we ask for
Yeah.
more data, so we just know?
Sure, I check the box, is it a fishing boat, is it a surf?
Yeah, okay.
That's.
That might be
That's fine.
helpful to know, that we know
Yeah.
how big the problem is or isn't.
Yeah, no.
Yeah.
Any other, well, I don't, if you weren't done, I'd give you more space.
No, I had the aha and that didn't.
Understood.
Fair enough. Any other questions? Okay, super. Well, thank you so
Yeah,
much.
sure.
I really
Thanks for your
appreciate.
time.
Yeah, well, I appreciate you coming to testify. So thank you. Okay, and so we're gonna same topic, or at least same bill, I should say. We're gonna move to Mr. Cahoon, who is with us remotely. Welcome.
Hello.
Hello.
Yeah, good good morning. My name is Barry Cahoon. I'm here today representing the Joe's Pond Association as its water quality director and Eurasian Water Milfoil Management Coordinator. Joe's Pond is a 400-acre lake straddling the town lines between Danville in Caledonia County and Cabot in Washington County. Joe's Pond is named after an Abenaki man who aligned with and guided the Vermont militias in the Revolutionary War. Thank you for providing me the opportunity to present to the committee the experience of the Joe's Pond Association related to its efforts to collaborate with the Vermont Agency of Natural Resources to establish a boat inspection station at the state-owned fishing access area. Our purpose and goal is to prevent introduction of aquatic invasive species into Joe's Pond and to avoid the export of invasives to non-infested Vermont water bodies. In addition, my testimony will include suggested amendments to S-224 as introduced that will, if enacted, establish aquatic invasive species spread prevention as an authorized use of state-owned fishing access areas at a priority level reflective of its vital importance to preserving the ecological health of Vermont lakes. I sent an email this past Monday to each committee member with attachments providing the text of this testimony today, as well as supplementary supporting information. Please do not consider my testimony here today is only about Joe's Pond. The Joe's Pond Association's experience is representative of many other lake associations' interactions with the Department of Fish and Wildlife relating to this issue of aquatic invasive spread prevention facilities at fishing access areas. The recommendations I offer here today are intended to address and resolve conflicting priorities in support of long-term ecological well-being of all Vermont lakes, something that seemingly would be a shared goal of both Vermont Lake Associations and the Agency of Natural Resources. The association has operated a greeter program at the Fish and Wildlife fishing access area for over a quarter century, absent a boat wash facility. Unfortunately, despite robust staffing levels and training, the invasive aquatic vegetation known as Eurasian water milfoil was discovered in August 2024. The association immediately mobilized to contain the proliferation of this insidious, aggressive, and persistent invasive, which has now infested over 100 Vermont water bodies. Yet, despite tremendous financial expenditures and efforts by the association membership, contracted harvesting, education, establishment of a SNUBA supported dive team that expended hundreds of person hours, hand harvesting, and much, much more, Eurasian water milfoil at the end of 2025 was more widespread around the lake than it was at the end of 2024. The invasive milfoil infestation dramatically elevated the awareness of the Joe's Pond Association as to the critical need to prevent the introduction of additional aquatic invasives into the lake. As well, the association believes it is our responsibility to prevent the export of invasives, particularly export of invasives from Joe's Ponds to other water bodies. A fully equipped boat inspection station is absolutely essential to achieve these purposes. The association believed, naively as it turns out, that the Department of Fish and Wildlife would share and embrace the critical need to avoid introduction of invasives into and export from Vermont lakes by collaborating with the association to facilitate the establishment of a boat inspection facility at the fishing access. Without getting into all the details of the association proposal, I have provided to the committee members via email attachments documenting the communication exchange between the Fish and Wildlife Department and the association, including a comprehensive rationale for why it makes little, if any, sense to prioritize parking spaces over aquatic invasive spread prevention facility. A site plan and preliminary project design was also included. In coordination with the Federation of Vermont Lakes and Ponds, the association offers these specific revisions to the provisions of S224. On page 11, following line 12, the following provisions should be added. 4, the Fish and Wildlife Department shall work collaboratively and to resolve any conflict with any entity as defined under section 1453 of this title, proposing establishment and operation of a boat inspection station for the purpose of aquatic nuisance spread prevention so that the lake protection facility and other authorized uses can reasonably be accommodated. This provision, if enacted, would complement and support existing statutory provisions in section 1451, quote, that says, "It is the policy of the state of Vermont to prevent the infestation and proliferation of invasive species," unquote, and 1453, requiring that ANR work with, among other entities, local interest organizations, such as lake associations, to develop aquatic invasive species controls. Secondly, because of the essential priority of preventing introduction of aquatic invasives into Vermont lakes is of paramount importance in long-term protection of fish and wildlife aquatic resources and associated wetlands habitat, an aquatic nuisance inspection facility listed in rule as the lowest priority authorized use of state-controlled fishing access areas does nothing to resolve the refusal of the Fish and Wildlife Department to recognize this absolute necessity. By not collaboratively collaboratively achieving aquatic invasive spread prevention, the day will come when very few, if any, parking spaces will be required at a fishing access area because of profoundly diminished and degraded aquatic habitats, native species populations, and natural resources. When this occurs, the short-sighted nature of disallowing a boat inspection station in order to preserve a few parking spaces may finally become crystal clear. Therefore, S224 as introduced should be amended to delete lines 1 through 3 on page 14 and be replaced on page 13 at line 8 as follows. 4.1, approved aquatic nuisance inspection stations for inspection of vessels entering or exiting lakes pursuant to 10 VSA section 1454. With this change, boat inspection stations will become the highest priority authorized use and will substantively contribute to the lake protection operations that are most vital to preserving the social, economic, and ecological values of Vermont lakes. We live in a far from perfect world. Navigating through life and achieving our purpose frequently results in conflicts and requires resolution through compromise. That the inability to accommodate 100% of desired parking 100% of the time is deemed and drawn as a red line represents a rejection of the opportunity for compromise and collaboration through which achievement of a higher purpose and a mutually beneficial outcome becomes possible. You know, the most profoundly distressing aspect of the current situation is that the Department of Fish and Wildlife's resistance to working affirmatively with lake associations to facilitate and enhance aquatic invasive spread prevention is that it not only represents an abdication of their responsibilities under 10 VSA section 1453, but then leaves all the staggering costs, efforts, sweat, and tears associated with aquatic invasives containment and management to the lake associations in perpetuity, sacrificing a few parking spaces, and in the Joe's Pond case, just 2, seems to be not a lot to ask, nor a lot to give. And finally, the Joe's Pond Association developed a preliminary design for the boat inspection station that included an approximately 3,000 square foot encroachment into a wetland buffer area in order to minimize loss of parking space. However, the Fish and Wildlife Department contended that the Vermont Department of Environmental Conservation, quote, wetlands program would not permit, unquote, the prospective encroachment. The association has performed a brief and partial search of the DEC database of recent wetlands encroachment permit decisions and has found half a dozen regulatory actions wherein permanent wetland and wetland buffer encroachments ranging from 6,000 to 20,000 square feet have been approved. These projects are all of substantially greater magnitude than the prospective encroachment associated with the association proposal. In addition, these projects provide little or no identifiable associated ecological benefit, particularly in comparison with that which would be achieved by the association proposal. If the Joe's Pond Association proposal for 3,000 square feet of wetland buffer encroachment were to be denied, such action would be entirely and egregiously inconsistent with prior DEC wetland regulatory decisions. The association offered to amend our preliminary project design to increase the wetland buffer encroachment, subject to regulatory review, in order to further minimize loss of parking. But this mitigating approach was also rejected by Fish and Wildlife. The same reasoning about short-sighted decision-making applies here to minor wetland encroachments, which represent little or no measurable diminishment of wetlands functions and values, yet can provide immense benefit through long-term protection of wetlands habitats all around the lake from degradation by introduced aquatic invasives. The A&R wetlands permitting data upon which this preceding testimony is based has been provided by email to all committee members. Vermont Lake Associations are the primary stewards of our invaluable lakes and ponds. Lake associations and their members suffer disproportionately and must shoulder the burdens associated with the social, financial, and ecological costs of aquatic invasives proliferation and management. As the Joes Pond Association works to discharge its responsibilities to our membership, to Joes Pond, and other vulnerable water bodies to implement a complete aquatic invasives spread prevention and containment program, we can much more effectively accomplish our purpose when the ANR is acting as a collaborative and supportive partner. The Joes Pond Association appreciates the value of public access to Joes Pond and all public waters and recognizes the constraints of limited space. But the current situation begs an honest assessment of our collective shared purposes and priorities. We hope through enactment of these recommended amendments to S224 that a functional and mutually beneficial relationship between the Department of Fish and Wildlife and Lake Associations can be formed to minimize the likelihood of aquatic invasive species proliferation and its associated ecological losses. Thank you again. The Joes Pond Association urges you to pass S224 with the above suggested amendments. And if I've got any time left, I'd be pleased to answer any questions.
Great, thank you so much. Really appreciate you taking the time to share that with us. Any thoughts or questions? Yes, go ahead.
More thought, and thank you, you actually articulated something I had been rolling around in my head, which is that this is an emergency, and we're not treating it like an emergency. That we actually should take your suggestion, at least in my view, and make clear statute that by statute that controlling or hopefully even eliminating, make that the target, spread of invasive species is a top priority for the state. We're not doing that explicitly, and we should do it. And I also actually happen to agree, I really don't care about parking spaces compared to people trying to keep the lakes free of invasive because in my area, the lakes that I grew up using are now invasives, and I don't like it. It's made up, and having that happen to another lake, because another lake in Vermont is anything we can do to let that happen, we can do. And I think we haven't made it priority.
Thank you. And just in order of hands that I saw, we'll send a party.
Well, I have a question. I don't know if it's for Mr. Cahoon or for Senator Bombards or whomever, but are the boat inspection stations the nuisance, aquatic nuisance inspection stations is what he's suggesting? Those are different than the decontamination things that we've been talking about, that, you know, they're not like huge water things that was, okay, they're just people looking to make sure you don't have milfoil on your boat before you put it in, right?
We have a real estate.
Yeah, but I just wondered what they, so it's not, doesn't take up a ton of space.
Just to, and just to, if I can piggyback on it, just to clarify, Mr. Cahoon, what you're talking about would have just taken up 2 parking spaces.
That's correct. There is a distinction between what we're terming a boat inspection station or facility and a decontamination station, which is a term used to apply to wake boats. What we've had a boat inspection, a greeter program, but it has no boat wash facility. That's what's critically important. That's what takes up the space. Is a pad, a plate, you know, a trailer or a building, you know, with a pump and a water heater and, you know, a water supply and all that, so that you can actually use a high pressure hose, power washer to hose the trailer, the boat off, and make sure that nothing's attached to it and stays attached to it. So you're not having invasives coming in, and you aren't sending invasives out to another lake.
Okay, we're gonna go Senator Beck.
Yeah, that was kind of where I was, Barry, Scott Beck here, is to make sure that when you say boat inspection station, you're really, maybe this is covered through definition, but that includes a washing station.
Yes.
Okay, not the,
Right.
but it does include wash. Okay, that's what I want to make sure.
It's fair. And
Just a question,
yes,
can we get a copy of your testimony?
It's on the website. It's on the website.
Oh,
You need to refresh.
I got retarded.
Yeah, my written, the text of my testimony, as well as I think three attachments, including the preliminary design of the facility, the communication exchange between the association and Fish and Wildlife. And the third thing was, geez, that escapes me right now. Yeah, you have it anyway.
Thank you.
Good guy.
okay, and I have a couple other questions. One of the things that we were discussing the other day is with boat wash stations. We have questions about the runoff from that. So, does the runoff from a boat wash, like where you have it, is it just going right back into the lake? I suppose if it's a boat that's just coming out, it doesn't matter, but if it's a boat coming in, that may matter more. But I guess if you could comment at all about the runoff.
Right. The facility will have to include containment elements so that the water you're using to wash the boat off is either contained or filtered so that there is no direct discharge back to waters of the state.
Okay, that's good to know. And then I want to recognize that this is, you may not have this, and that is perfectly fine. But something that came up in testimony the other day, as we were talking about the primary uses of the access points, or the prioritized uses. There's a question of so did Joe's Pond recently get a grant from the federal government? Is this ringing any bells?
No, we
Oh,
haven't.
okay. Okay, if there's something about that, I'll follow up offline, but if there is nothing to follow up about, then that's okay too. There was a question about the interaction between federal law and state law, so we can follow up on that another time, but any other questions? Okay. Well, thank you so much. Really appreciate your suggestions and all the work that you do for Joe's Pond and helping to protect waters around the state. So thank you.
Great, thank you. Thank
yeah.
you, Tim.
Okay, and we are running a little bit behind at this moment. We're anticipating that we may have Judge Zone coming in at 11. And so
Yes.
I can, Madam Chair, I can certainly come back as an attorney, one just learns to never keep a judge waiting. But my testimony is actually it's more about aquatic invasives and wake boats and the fishing access issues, so it actually dovetails Mr. Cahoon's. But really, your discretion.
yes, so is it relatively short, or could you make some of your comments if Judge Zone comes in, we can transition and then.
It can be relatively short, absolutely.
Thank you. I do want you to be able to say all the things that you want to say.
Well, I can do that.
Okay.
So let me. See. Excellent. So for the record, Jared Carpenter with Lake Champlain Committee. It's nice to be with the committee and not talking about the salt bill. But thank you so much for your past support of the salt bill. So I'm here to talk about S224 and the capacity of, well, a little bit on wake boats, more on the aquatic nuisance language that is within the bill, and also the rule. I've asked Jude to post the draft use of public waters rule under my name under today's date. If you want to find it, because I do have some references. It's, in my experience of doing this a while, it's been an interesting that there is a draft rule going through right now where the public comments are due next week, and a bill that's going through at the same time. Some sections are complementary and some sections are in conflict. So, so at any rate,
This is the aquatic invasives identification chart that Lake Champlain Committee puts together, just very quickly. It identifies, we have what's called our CHAMPS program, which is people who take this information and are around Lake Champlain looking for not only current aquatic invasive, there we go. The little triangle with the exclamation point in it, and it is species of concern that have not arrived at the lake yet. Things like round goby and such, and I need to work, this is a big document, so I'll work on getting it to you, but in the interest of time, I won't do the whole thing.
And
Want me to pause?
I apologize because we do have, before you really got into it, you know, because there's a lot to be said.
I can park and come back.
Amazing. Okay,
That would be perfectly fine.
thank you. Thank you for your flexibility. Really appreciate it.
No, of course.
Okay, so we are joined virtually by Judge Zone. Welcome. So.
Morning, thank you.
Oh, yeah, for sure.
So I understand, Tom Zone, Chief Superior Judge. And I understand the question the committee had was on section 1 of S-224.
Section 4. What's that?
Section 4.
Yes. Oh, no, section 4. I'm sorry. Okay, my apologies. It's actually section, if you want to come back another time, if you're not ready to come in at section 4, then that's okay. Sorry about the miscommunication.
I thought it was section 3.
So I guess
Section 4 looks correct.
It's the bottom of page 6.
yes,
Draft
and
2.1.
7. So I suppose it'd be section 3 and 4. About the Judicial Bureau having authority over. Yes.
I was all excited thinking, wow, this is an easy one, section 1, I can handle that one.
So however you want to handle it is fine. If you want to come back, or if you're prepared to talk about 3 and 4, that's great too.
I would want to seek input from someone in the Judicial Bureau before I opined on that section, if that was okay. I'd want to do a little background on it, so if I could come back on that, that would be appreciated.
That's perfectly fine, no worries, and my apologies, we'll get you back another time.
But can I tell you something about section 1 that I noted?
Sure, yes, absolutely. Would love to hear it.
So section 1 talks about appeals going to the environmental division. And it says on page 4, appeals from a final act of a municipality under a bylaw or ordinance approved shall be to the environmental division. I can give you the long version with the nuances, or I can give you the short version. I'll start with short, but I'm happy to go long.
Wait, Judge Donet?
Yes.
I think, are you looking at S-224?
Yes.
Okay.
So, on page 4, which
Lines
line?
1 through lines 1 through 3.
Oh, you want, are you version 2.1? What version?
I have the introduced version. I am sorry.
Okay.
We're catching up. Introduced, page 4. Oh, okay, there we go, appeals, all right, with you.
So the short version is this. Jurisdiction in the environmental division is conferred under Title IV, Section 34 of Vermont statutes. They talk, when you look at Title 10, appeals, Section 1 of Section 34 says jurisdiction of matters arising under 10 VSA chapters 201 and 220. It does not say Chapter 49. And there's a difference between bylaws and ordinances, because ordinances usually go to the Judicial Bureau. And so in order to make it very clear and avoid any questions, my suggestion to the committee would be that you add Chapter 49 to 4 VSA 34 in subsection 1 to make it clear that these appeals, that there is jurisdiction for these appeals. And you don't have, right now in the bill in 224, there's no provision for changing the jurisdiction. But to me, that's the cleanest way that you can assure that no one could argue they don't have the ability to take care of these appeals on these when they come up from ordinances. I could make a circular argument and say, well, here's how it really fits in. But the reality is, if you can make it direct, we might as well do that in the statute to remove any ambiguity and any potential challenges.
Okay,
It's for VSA 34,
Yes, if you look
chapter 39, is that what you said?
chapter 49, because the change to the section 1424 of Title 10, that falls within chapter 49 of Title 10.
Got it.
That would just straighten out that. And please, let me know when you'd like me to come back, and I will get some background on sections 3 and 4. I'll be ready to go.
okay, wonderful. Thank you. My apologies. Your flexibility. So we'll circle back to it. And this, but nonetheless, this is helpful. So really appreciate your testimony.
Thank you. Have a great day.
Yes, you too. Cheers. You'd like a quick break? Sure. That's fine with me.
That's pretty quick.
We'll take a minute.
We're alive.
Oh, right, sorry, this is Senate Natural Resources and Energy. We're coming back from a break, and we're joined by Mr. Carpenter.
Hello again.
Hello again.
So no more presentations. I just wanted to briefly show you.
But your pictures were good.
I know, what I'm gonna try to get, and we do have little cards of them. They're identification cards that you can flip through. And I wasn't able to bring any down now, which is probably a good thing, because I would hand them out and you spend all your time looking at them and not listening to me. But I will try to bring them down. Because we have the Chance program, which is funded through the Basin, Lake Champlain Basin program, which has volunteers that go around and look for aquatic invasives, particularly these species that have not emerged yet. I mean, the open plan was discovered, which is a very small open plan, was discovered a few weeks ago, months ago now. Round goby is a concern, but getting to the conversation that you had with Mr. Cahoon, hopefully pronouncing that correctly, and Senator, as you mentioned, aquatic invasives are a huge concern for Lake Champlain, and obviously a lot of other waters, and really, we agree that more and more efforts need to be made to stop the spread into all of our waters. Yes, they can be transmitted through ducks and things like that, but we really need to do what we can to spread aquatic invasives, stop the spread of aquatic invasives. So I am going to be talking largely to the current draft, 2.1, the draft rule, which is posted, and as I said, there's some overlap and some conflict. But I'm not going to talk about the delegation and fishing tournaments and things of that nature, so I will sort of jump in. Wake boats. Lake Champlain Committee is not engaged in the wake boat issue in the past couple of years, but is now doing so on a limited basis. We have discussed it internally with the board and of course the executive director, where Lake Champlain Committee has always been supportive of those inland lakes that want to restrict or ban the use of wake boats, but Lake Champlain's really big. So it's not something that we've gotten into. There's always been this concern that if you ban wake boats on every other lake, they're all going to wind up on Lake Champlain or Lake Nymphomagog or Lake Wallace or the Connecticut lakes. Those are pretty much the lakes that have not been included in this rule because they are either interstate and or international lakes. So they just are generally not included in those restrictions and wake storm zones. But I'll get back to that in a moment. But we do have concerns about the spread of aquatic invasives on all boats, not just wake boats. If you go to page 6, I'm gonna walk myself through this. It's already actually been removed. We're fans of the designation of a home lake. It makes sense to try to determine, like you were saying, Senator, collect the data the best we can. The decal that seemed to be, that was in the first version, seemed to be something that would be difficult for DEC's lakes and ponds to implement. So we don't think that is necessary. But there needs to be some sort of certification of decontamination or some way of identifying that decontamination has occurred. My understanding is lakes and ponds department program has been thinking about this internally. I think that is key to know, especially with out of state as well. We need to know some way that these boats are coming in, they've been decontaminated from their own waters, and they're not bringing anything into our home lakes, ballast waters or otherwise. Something else that's worth exploring is, you've talked about it a little bit, when you register your boat, there's a line down at the bottom that says, is this a wake boat? Yes or no, and you check the box, and you list your home water, and then it says, and the DMV is required to then send that information along to the Agency of Natural Resources, and they can compile a database of how many there are registered in the state where the home waters. My understanding is most wake boats, as the gentleman was saying, don't leave their home waters. They're big, they're expensive, they involve moorings, and it's not like your Boston whaler you're taking all over the place. So I think once we identify home waters and decontamination, that will help really contain the spread, contain the ballast water issues. So it might be worthwhile asking Agency of Transportation. Again, my understanding is lakes and ponds, and I think they talked about it a little bit here, has talked to DMV a little bit about it. DMV was not thrilled with the idea. This body can compel them to be, well, maybe not thrilled. But to reconsider.
Well, and just, so you know, I've reached out to try to find out who the right person is to talk to at the DM, well, with AOT.
Okay.
Yeah.
No, because I think that seems like it would not be a very, well. I might not be, but it seems like it might be a better solution. Pages 10 and 11 are regards to the decontamination stations. Oh, yes. So, the draft rule also has, very specific, new rules on clogged invasives and checking your boats and training for people who man those stations. I think it complements, I might be missing something, but I think it complements this language, pretty well. We believe that there's a section in here, page 10, line 14, about, oh, I've got my bills missing, but at any rate, there's a section about signage, that posting signs at access stations for public education, this issue. I think is gonna be really important.
Page 9, middle of the page.
Thank you.
Page 9, okay, that's right, page 10, we're gonna make this.
No, page 9.
Okay.
I'm sorry, I didn't update my page. In terms of the fishing access areas themselves, I know Department of Fish and Wildlife has concerns with having them for decontamination. Yes, I understand and that there is concerns with federal funding. That hunting and fishing access, hunting and fishing needs to be a main priority. That's not to say that aquatic nuisance can't be the exact priority right behind them until you get to other priorities for those areas. It's, I think it's something that needs to be considered a little bit more thoroughly by Fish and Wildlife, obviously with some caveats in the language that maybe Fish and Wildlife does have final veto. My thought would be, and I can consider some language and talk to Mr. Cahoon as well, it's sort of the same area. That the Lakes and Ponds program, the Fish and Wildlife Department would get together and put some guidance together on exactly what standards need to be for these specific areas and how many parking spaces they need to have and basic some standards. It seems to be a little bit all over the place on when it can be used and when it can't be used and very subjective. But I think if you put in some more guidance and some more structure on when these stations can be used for decontamination and aquatic invasive inspections, as well as if they can't, for whatever reason, that a reasonable effort be made to find an alternative site close by, that the issue is not just sort of completely disregarded because there's not enough parking spots. It's gonna be hard to base in my mind, I get it, there's only so much parking in certain areas, but some days you're gonna have 5 people show up and some days you're gonna have 50 people show up. I don't think you can have a limit on parking, there's gonna have to be other factors that are involved in order for the aquatic invasives are addressed. And I don't know, this needs to be talked about, I think, in terms of maybe a memorandum of understanding or some sort of guidance between the two groups on. It can't just be, in my mind, in Lake Champlain Committee's mind, just be, you know, we have to keep X amount of parking spots available for people who may or may not show up. It's a little subjective and it's a little arbitrary in my mind about how this is determined.
Yes, go ahead.
No, you're fine, thank you. I feel like I should have asked this question a while ago, but it's coming to my mind now, so I'm gonna ask you, Jared.
Okay.
The programs where people inspect boats or wash boats, setting aside the decontamination of wake boats, but
Right.
the inspection and washing of regular boats. Is there evidence that is helpful, that it's working, that it does prevent, or is there any data on that?
That's actually a good question. Let me look into that. I don't know. I would think that it's, you know, from a basic perspective of rinsing down the boats.
Yeah.
Making sure there's nothing clinging to it is.
It's logical that it makes sense, but I'm just wondering if anybody's tracked it.
And done in such a manner as you all suggested, that it's not so close enough to the water, you know, it's gonna be done in a location, but the water doesn't go back into the water body. Let me see, I can reach out to the Lakes and Ponds program and see if they have some information, that's not, or my folks, what you doing?
Seems like somebody would have written a paper about it or something. I mean, it's logical that it is helpful, but I'm just wondering about.
It's a good question. Then there's another question.
Just in that issue, I know that Lake St. Catherine Association keeps data.
Oh, do they? Oh, that might be.
But, and that's the thing, it's like, you know. When everybody's looking at it, nobody in particular is, so someplace we gotta have somebody designated to be responsible for that data.
Yeah, it would seem like the Lakes and Ponds is
Yeah,
the department or whatever it's called, office.
Federation of Vermont Lakes.
Yeah. So. The language, if you go to, I'm looking at the right route now, if you look at page 10, line 7, and then go down to, lines 13 and 14. The way it's written now, I think is fine. It's fishing access areas may be used. I mean, there is flexibility, and if the aquatic nuisance inspection station conflicts with the use of a higher priority, they may modify the activities until the conflict is remediated. This does give the Department of Fish and Wildlife the veto authority and the flexibility that they need, and I think that's important. But I also think that there needs to be greater consideration given to aquatic nuisance, addressing aquatic nuisances. And I think with some tinkering of this language and maybe some requests for some guidance or an MOU, you can find a spot that addresses fish and wildlife concerns, but also brings in the aquatic nuisance issues as well. So that's sort of my thinking about all of this. And Ellen hasn't shown up yet.
We do have another question here.
No, you almost think that the Fish and Wildlife fisheries biologists would not be involved in that. Because that's what we're talking about.
By all means, I mean, I think it's something that if it's, it needs to be discussed, I think, a little bit more broadly and put more people together. I don't think we need to put together a study. But maybe something along the lines, of asking for some sort of memorandum of understanding or some sort of guidance that they could then come back to this committee in December and discuss, and here's where we hit the sweet spot. Engaging stakeholders would be great. I'll look at Mr. Cahoon's language as well. It sounds like he's thought about this for a while. Wake boats. For Lake Champlain Committee, we're not asking that, we don't think wake boats should be addressed in statute. In terms of this distance of feet and things of that nature and acreage, that seems to be something that should be in rule and be more flexible than it would be in statute. Because the science may develop that 500 feet isn't enough and it should be a different distance, or maybe a different depth or things of that nature. But if you get a chance to look at the rule, it is on pages 16, 17, and 24.
Of the rule.
Of the rule.
Which we don't have yet, but we're gonna get it.
It's under my name.
Oh, it is amazing, okay.
You mean the proposal?
The
The
proposal comments are due next week. It defines wake sport zones and says, you can't use them within 500 feet of loon nesting, 500 feet of an individual or another vessel, 500 feet from shoreline. And then it defines what a wake zone would be, and I think it's 200 feet wide, 3,000 feet long, and then it establishes the acreage, as the gentleman was talking about before. So that's all in the rule. It's 115 pages, the draft proposed rule, but it's only the first 25 pages of the rule. The rest of it is these specific restrictions, lake by lake by lake, of what can be used and what can't be used, which is interesting in its own right. Now, we're not proposing a wake zone in Lake Champlain. It's too big, but in rule, and we are talking about this with the Lakes and Ponds program, there should be distance and depth requirements on Lake Champlain, Lake Nymphomagog, Lake Wallace, and the Connecticut lakes. For the same reasons, the distance rules you have, not only for public safety between swimmers and other boaters, kayakers, from shore, it's because of shore erosions. And for Lake Champlain, it's the depth. The depth is 20 feet, but you shouldn't use it in areas you have to use it 20 feet or deeper. Studies are starting to show, and I won't quote from it, but it's a field study of recreational powerboat hydrodynamics and their impacts on the water column and lake bed, July 2025, from the University of Michigan, University of Minnesota, is finding that boats and wake boats in general stir up the sediment in the bottom. What's stored in the sediment of Lake Champlain, we're spending in the course of $45 million a year to prevent phosphorus. So you can start using this in the shallow bays. The concern is it's going to start stirring up the sediment. It's going to start stirring up the phosphorus. And it's going to contribute to our cyanobacteria issues. A great example is Lake Carmi. If you recall, they had the aerators that didn't work, and they've now gone to the alum treatment. It's my understanding from one of the staff scientists at LCC is that the aerator actually contributed to the algal blooms being worse because you had it on the bottom and it was stirring up the sediment and it was stirring up the phosphorus that's buried in the sediment.
Brilliant.
So this is a concern. Now, Lake Champlain is different depths and all over, so it's gonna be hard to enforce in some areas, but Mallett's Bay is under 20 feet, it's the entire bay. Some areas will be easier to enforce than others. But again, we're gonna submit the comments on this. We're gonna continue, LCC is gonna continue discussions with lakes and ponds about hopefully getting some rules involved in Lake Champlain as well. And so those are the two areas that I wanted to hit on. I can continue conversations about the aquatic invasives and potential language on potential guidance or something like that, if that's okay, Madam Chair, and get something to the committee and yeah,
Suggestions welcome.
thank you.
So, thank you.
That's good.
Any questions?
No, thanks.
Yeah,
Specific-
thank you.
Specific suggestions.
All right, thank you all so much, and
Okay. All right,
You got
super.
more?
We're gonna
let's council.
end the day where we began. Circling back.
Take us home.
It's gonna take me a second to transition here. Thank you for coming back.
Ellen Shankowski, Office of Legislative Counsel, so we were looking at draft 3.1 of S 138 C-PACE, Commercial PACE Program. And I believe we left off on page 4.
Okay.
All right, so, to remind you, the new language in the paragraph is highlighted in yellow, or the yellow reflects that something has changed, some language has been removed, some language has been added. So on page 4, nothing, I think where we left off was at the top of the page, so the language, weighted cost is highlighted. Because the language that was taken out here was that, the efficiency utilities, I think specifically Efficiency Vermont, would do the calculation for lifetime of the project, so that has been removed, seeing as how they probably aren't going to be involved. So notwithstanding any other provision of law, at the time of the transfer of property ownership, excluding foreclosure,
Sorry, there's a question.
Why was it removed?
Oh, because Efficiency Vermont's not likely to be involved
Oh,
in this at all, and there's gonna be a performance analyses performed by licensed engineers already. So, yep.
and it's possible, depending on how you establish the authority, the program administrator would largely set some of these baseline.
1 minute.
So at the time of transfer of property, including foreclosure, the past due balances of any special assessment under the subchapter shall be due for payment, but future payment shall continue as a lien on the property. In the event of a foreclosure, the past due balances shall include all payments on the assessment under the subchapter that are due and unpaid as of the date of the action is filed. And all payments on the assessment that become due after that date and that accrue up to and including the date title to the property is transferred to the mortgage holder, the lien holder, or a third party in the foreclosure action. So a person or entity acquiring title to the property in the foreclosure action shall be responsible for payment of the assessment that become due after the date of such acquisition. A participating municipality shall disclose to participating property owners each of the following: the risks associated with participating in the program, including risks related to failure of participating property owner to make payments and risk of foreclosure.
Can I pause for a second?
Yeah.
Just wanting to note that, as a part of the package of documents that the, program administrator would adopt, that would include the standard set of, one of the things that it would include is this, the disclosure, standard disclosure.
Yeah, and this, I believe all this language exists currently in residential case, and so it may make sense here to change that to say, and say, well, you can think about it, if you wanna change it from municipality to just a program administrator, depending on how this is structured, but. The property owner will probably have some contact with the municipality.
Mhm. Yeah, I suppose it doesn't matter who provides it as long as someone provides it.
Yeah.
Yeah. Seems good.
Alright, on to page 5. Still no changes, and so the municipality shall also, provide the provisions of subsection H of the section that pertain to the prepayment of the assessment. A written agreement or notice of an agreement and the analysis performed pursuant to subsection B shall be filed with the clerk of the applicable municipality for recording in the land records and shall be disclosed to potential buyers prior to transfer of property ownership. Personal finance information provided to the municipality by a participating property owner or potential property owner shall not be subject to disclosure under the Public Records Act. If notice of agreement is filed instead of a full written agreement, the notice shall attach the analysis performed pursuant to subsection B and shall include at least each of the following: name of the property owner as grantor, name of the municipality as grantee, the date of the agreement, the legal description of the real property against which the assessment is made pursuant to the agreement, the amount of the assessment, and the period during which the assessment will be made on the property. A statement that the assessment will remain a lien on the property until paid in full or released. And on to page 6. The location at which the original agreement may be examined. So here, previously it said the original or true legible copy can be examined, so we just struck true legible. Because everybody, no one's probably writing this by hand. So
Wouldn't create a loophole with it.
either way, it should be the original, so if it was.
Original is in the.
I think this is actually cutting off the potential of a Xerox machine or what are the mimeograph? Where you're copying a handwritten, what do they call it? 4-way time.
Yeah, ditto machine.
Ditto.
Oh, gosh.
Is that the one that had the piece of paper that had all the ink on it?
Yeah,
Yeah.
the ink that smelled just so, if you went into the teacher's lounge at
Yeah.
lunch, you could smell the ditto machine.
Yeah.
Oh,
That was, did not experience that.
child is.
Yeah, it's definitely in the Xerox era. Okay,
Alright, so on page 6, there is some new language to this draft, subsection E. Prior to entering into the written assessment contract, the property owner shall obtain and furnish to the local government a written statement executed by each holder of a mortgage or deed of trust on the property, securing indebtedness. In their sole and absolute discretion, that consents to the assessment and indicates that the assessment does not constitute an event of default under the mortgage or deed of trust.
shall I,
Do you want it?
Sure, context,
This is a suggestion.
yes,
It replaces the language that was there previously, which was that the property owner shall provide the holders of any existing mortgages notice of intent to enter into the assessment. And so this is a variation of that.
yes, so the key here is that the mortgage holder, AKA like the bank, is providing consent that they're doing this. And this is one of, I believe, I mean, we'll hear testimony on this, but when we hear from like Chris Delia about this, that he may be interested in that statement, and I don't want to put words in his mouth, but I believe it's important. So we'll go from there.
Okay. Subsection F on page 6, the combined amount of the assessment plus any outstanding mortgage obligations for the property shall not exceed 90% of the assessed value of that property. With respect to an agreement under this section, assessments to be repaid under the agreement when calculated as if they were the repayment of the loan shall not violate 9 VSA sections 41A, or 43, 44, and 46 through 50. Those laws relate to interest on loans.
Sorry.
What?
Sorry.
Maybe,
Oh.
they're related to how interest is established for loans. And the maximum length of time for the property owner to repay the assessment shall not exceed 30 years. That whole section is in residential case, it's the same language, so.
Oh, the 30 years.
That whole subsection G
Oh.
is also what is used currently for residential case. Subsection H for projects under subchapter 2 of this chapter, which is residential case. There shall be no penalty or premium for prepayment of the outstanding balance of an assessment under the subchapter. If the balance is prepaid in full, projects under this subchapter 3 are not subject to these provisions, but shall be determined by the private agreement for financing of improvements. So this was language that was suggested. The first sentence is what is currently in subchapter 2 for residential case. So either we can rewrite that to be more clear, or we can just not include it, but I think the important part is that the proposal for CPACE is that there could be a penalty for prepayment.
Yes, that is neat. We do not want prepayment penalties for residential, allowing that for commercial. Okay.
On to page 7. Subsection I don't know why the highlighting is there on subsection I, it may have been carried over from the last one, because I don't think this has changed at all. But then on page 7, section 3277 is the new language. So in the prior draft, there was a rulemaking provision for DFR to adopt the underwriting criteria for CPACE. DFR under this draft is not involved at all. In its place is language relating to a program administrator. This language probably needs some work. I drafted it based on Maine's law and their program administrator. And so there may be things you want to add or adjust, but I was looking for another example. So, and just so you know, in Maine, I've only done a bit of research, but they have their Efficiency Maine Trust, that's their efficiency utility, they are the program administrator there. So, see, I think this is the first, and so one of the small things that may need to be fixed is that they recommend CPACE over and over, and so we actually could use that acronym in here if you'd like, if it's helpful. That's how they reference it throughout. So CPACE program administration. The entity that administers the CPACE program under the subchapter shall be referred to as the program administrator. A municipality that has adopted a CPACE ordinance may enter into a contract with the agency for it to serve as the program administrator and to administer the functions of the CPACE program for the municipality. So in Maine, they have an agency, Efficiency Maine. Towns have the option to ask them to be the program administrator and enter into a contract. Or the municipality itself and subdivision B serves as the program administrator itself. Currently just as agency. I do not know which agency would be best for this role.
Hoping to come back with some recommendations on that.
So if, so subdivision B, the town itself, could be the administrator to administer the functions of CPACE, including entering into the agreements with commercial property owners in its jurisdiction and collecting the assessments. So this is actually why I asked earlier about the level to which the municipality under this program you're envisioning exists, because I think But I don't know, that to some extent in other states, the municipality has little to no involvement because they have program administrators. So I just wanna make sure you just hear about those options.
Yeah.
Okay, I just remain confused about where's the money coming from that is being used to pay for the program, to pay for the improvements.
When, so my basic understanding of this is a homeowner.
Who's tilting?
Okay, you're right, so I was, well, cause this doesn't exist yet, sorry, okay. The property owner who is
Yeah.
eligible for this program. Seeks third-party financing. They have to, if they're going to be under this program, they have to be in a district that the municipality has approved. There's a contractual relationship with the property owner, the third-party funder, financer, and the municipality. The funder pays for the work done on the property. The municipality assesses the payback amount as part of the property tax. I do not know exactly how they calculate the assessed amount that is due every year. But it is collected in the same way that tax would be collected.
Okay, so some lending institution is giving the person the money to put on solar panels or heat pumps or whatever. And then the town is collecting the payments back
Mhm.
and then paying them to the lender.
Yes.
And the reason the town has to be involved is why? Why doesn't the lender just collect? I don't understand how, I seriously do not understand what the town's role is in this. And why we're asking them to be involved, unless it has to do with the lien. Does the municipality have to be involved in order for a lien to be placed on the property?
I do not know.
Okay. I just don't understand how the money part works at all, and so that's why it's confusing as to me why the municipality, how does this differ than just a regular commercial loan?
And you said it earlier that it's effectively a loan to the land. And so there's some, right, there's the lien, there's the.
Oh, because it travels with the property.
It travels with the property.
It's, let's see, it doesn't travel.
Oh, right.
Yeah, it's true.
Yeah, so, yeah,
Yeah.
It doesn't. travel.
so whoever owns the property has to pay it back.
Right.
Okay, and then there's a lien put on the property
Yes.
till the loan is paid off, there's a property lien.
Yep.
Okay, I just,
Right, and you're right that the money would be coming from this, a capital provider, which is actually referenced later.
yeah,
Yeah.
okay. It just seems like if the town has to be involved to do the administration of collecting the money and then paying the money to the lender, and then there's gotta be some state agency that's involved. I'm wondering if the juice is worth the squeeze here, because the towns that are gonna do this are gonna be only our most sophisticated towns, I would think. And then there's gonna be some kind of cost to the state.
So. The way that it's structured here, as I understand it, is that municipality doesn't have to, they could they could be the administrator and then they get to charge a fee for that service. But I think it can also, it should be available, as long as the municipality has approved that this can happen in their town, that it could be handled by the statewide program administrator, so it shouldn't theoretically be just available. This program shouldn't just be available to the largest towns. It's whether or not the municipality wants to take it on as the program administrator themselves. They could, and no, maybe it's possible that no one may want to.
Yeah.
We can take more testimony on all that.
Okay.
Yeah, sure.
Yes, New Hampshire, we probably hear from Maine, cause we're certainly,
I was thinking, I don't think it's all the same thing.
Yeah, trying to figure
Yeah.
out, is this worth it?
Fair enough.
So at the bottom of page 7, model documents, educational materials. The agency shall develop and provide to municipalities model CPACE ordinances, model CPACE agreements, and other model forms and documents and educational materials for use by municipalities on page 8, property owners and capital providers in the implementation of CPACE programs. The agency may enter into a contract with the CPACE municipality where the agency shall serve as the program administrator of the municipality, collect fees necessary to administer the CPACE program, and subcontract with one or more third parties to perform part or all of the duties of a program administrator on behalf of the agency. Other than the fulfillment of its obligations specified in the CPACE agreement, neither the agency nor municipality has any liability to a commercial property owner for or related to energy savings or resilience improvements financed under a CPACE program.
I hate to, but just to make sure I get this, my head's exploding this another time here. So there's another level of the administrator beyond town doing this.
So-
What does that mean? What does that mean?
So we can take some testimony on that, but there needs to be somebody of statewide who is, who has the ability to, generate or adopt a sort of package of standard documents. And
But it's not like there's somebody else in the get other than the town.
so there could, I think, as I understand it, and we can take more testimony, but, that it could be. The billing could be run through the state agency, but it could also be run through the town. But we should hear more about that.
Yeah, so currently, as it exists in the state PACE, the municipality administers the full program, and they may or may not get some input from DFR. Other states that have adopted commercial PACE have started to move towards this model of having a program administrator instead of the municipality or in conjunction with the municipality. And so I do think that's one of the major changes under this CPACE program that you are hearing a proposal about. I didn't know what the duties of your administrator would be, and so I copied what another state has done, and you can adjust this, but I think that is sort of the proposal from some of the advocates, is that instead of having the municipality do things as Senator Hardy was just discussing, that maybe administratively burdensome for them or out of their interest, they don't maybe want to do that, you could have a state agency designated as the point agency for this instead of or in conjunction with the municipality.
Mrs. Miller, you still have to carry out the lead as it's part of
Mhm. Yes.
Well, I guess to my earlier point from the last time you were here, we're gonna make a list of things they should do, we should reference the program guidebook, just so that if we're gonna do this, but my question, it seems here, I mean, on page 8, their lines 7 and 8 is the state, so there's the municipality, then there's the state agency, and then there's language here about the state agency contracting with a third party to perform all or part of the duties of the program administrator. So essentially that becomes a private individual or company administering these loans. So why would we do all this and not just have regular commercial loans? And is there a way, I mean, maybe this is a question for Delia or some other banker. Isn't there a way to have the same kind of thing that happens in a commercial loan without setting up this whole complicated thing?
Yeah, it's state buy down of rates to subsidize that decision.
Well, I don't think it's a state buy down of rates, it's just a matter of like, is there a way to have the loan stay with the property? Cause that's why municipalities have to be involved. Is there a way to have a lien? You can put a lien on property without municipality being involved, I think.
They can, sure.
Exactly, a bank can do it, so why can't a bank do all of this? And that's what I don't understand, there's probably an answer to it, but I don't understand it.
Well, that's a good question. Let's flag it as a question to ask.
I keep thinking there's a reason politics are doing this, so.
Right, exactly, there's not a reason I just don't know what that
What's,
is.
what problem are they solving?
Access to capital, but why? I mean,
Yeah,
what's the barrier? I'm sorry.
So. The rest of this language, in the next few pages is all language that currently exists for residential pace, but adding reference that it also applies to C pace. So on page 8, section 2, section 3263, cost of operation of district. The owners of real property who have entered into written agreements with the municipality under residential pace or C pace shall be obligated to cover the costs of operating the district. The municipality may use other available funds to operate the district. Section 33264, rights of property owner. A property owner who has entered into a written agreement with the municipality for residential pace or C pace may enter into a private agreement for the installation of the construction project related to renewable energy or energy efficiency. I was wondering if you wanted to add resiliency here.
Yeah, let's do it.
Okay. Section 4, liability of municipality. A municipality that incurs indebtedness for or otherwise finances projects under this subchapter shall not be liable for failure of performance of a project. A municipality that incurs indebtedness for bonding under the subchapter shall pledge the full faith and credit of the municipality. So new language here on line 13. A municipality that enters into a written agreement with a property owner under subchapter 3, which is C pace, shall not incur any indebtedness or otherwise finance projects under this chapter, nor shall be liable to the failure of performance of a project, nor pledge the full faith and credit of the municipality.
So is paragraph C basically saying for C pace, A and B don't
Right.
apply?
Yeah,
Okay.
perhaps that could be written better. Section 5, 3268, release of the lien. The municipality shall release the property owner of the lien against which the assessment of residential pace or C pace is made upon full payment of the value of the assessment. On to page 10, notice of a release of a lien for an assessment under residential pace or C pace shall be filed with the clerk of the applicable municipality for reporting in the land records. And then section 6, 3255, collection of assessments, liens. Special assessments under this chapter shall constitute a lien on the property against which the assessment is made in the same manner and to the same extent as taxes assessed on the grand list of the municipality. And all procedures and remedies for the collection of taxes shall apply to special assessments. Notwithstanding subsection A, a lien for an assessment under subchapter 2, so residential pace, shall be subordinate to all liens on the property in existence at the time the lien for the assessment is filed in the land records. Shall be subordinate to a first mortgage on the property recorded after such filing, and shall be superior to any other lien on the property recorded after such filing. In no way shall this subsection affect the status or priority of any municipal lien other than a lien for a special assessment. A lien for an assessment under subchapter 3, so C pace, shall be exempt from the provisions of the section, and upon receipt of consent on to page 11 from lenders pursuant to subsection E shall not be subordinate to all other liens on the property in existence at the time of the lien for the assessment is filed on the land records.
So that explains why the residential base has to go through the town because. But if we're just sort of negating all of this, which I understand why we are, again, I'm not sure. Why the town is involved.
I'm not entirely sure if this language makes clear the level of subordination
Okay,
lien gets.
okay. like we might need to make it clearer.
Yeah, cause I understand in the lineup of liens for residential case, first mortgage is the most important. And then the pace, and then everything else. So, but it says that C-PACE is exempt from this, so where does that put it? And usually it's first in kind, I think is default, so would that make it last?
I think we should get testimony on this. I think the intent, well, let's get testimony on it. Yeah, about where it should fall and how clear it is.
And so, the last section, section 7 hasn't changed, but this is that, it's exempting. C-PACE from this, existing law that says you can't have prepayment penalties.
Yes. Okay. Thank you. So we're coming back, we've finished, we're only like a minute over.
Yeah.
Questions to keep asking about this, which is great. And we'll go from here.